morning to one and all. And
Sorry?
or your first witness,
Oh.
or your
Mr.
second.
Canfield,
Yes.
just
Oh, I'm sorry. I apologize. Yeah.
procedural point, could we have a break after the direct exam to allow the respondents to just organize their cross-examination this witness?
Yeah. So yeah, sure. Yeah, that's no problem. So
Your Honor, we have one matter of housekeeping that Mr. McDonald.
Sure.
Okay,
thank you. Thank you.
Good morning, Commissioner Cantwich. Good morning, everyone. Just yesterday, at the end of the cross-examination of Mr. McGeary, and I just wanted to renew my request that petitioner's disputed Exhibit 12, which was the PowerPoint presentation, be admitted as an exhibit in the case. You had indicated, Commissioner Cantwich, that you would defer that decision when I initially asked for it until after the cross-examination, and then when I listened to the proceeding, it doesn't sound like it was addressed, and I apologize for not bringing that to your attention yesterday. So I renew my request that be admitted as an exhibit in the matter. I believe the next number would be 14. And the basis of that is that Mr. McGarry testified that he wrote the document. He used it when he trained the recruits at the State Police Academy. He testified about the document, was cross-examined about the document. So for those reasons, I'd ask that it be admitted as an exhibit. I think it would be helpful both to the presiding officer and to the commission when they deliberate on this matter and reach a decision.
I appreciate that, Ms. Kiley. You want to be heard?
Just briefly, we heard from the witness that he had knew that he had written some of it as far back as when he was in Amherst. He did indicate that he had written much of the material, majority of it, I think was a word. I can't object to the admission of the document,
At this point.
obviously subject to the testimony itself.
Okay, thank you, Ms. Collins. Attorney Burke, anything?
I have no position.
No, Ms. Bourgeois, anything?
Only I was struck by how little they used the document, and I assume that was tactical, so I don't think it's been established as admissible or helpful to the question.
Okay, well, it's, I appreciate that. Yeah, Ms. Moscone.
No objection.
Okay, so yeah, okay, I'm going to admit that as exhibit.
I believe it would be number 14 if I read Legal Advisor Duca's email correctly.
That's up to Ms. Duca, so thank you.
Thank you.
Oh, I'm sorry, I always have to, thank you.
Sorry.
So, thank you very much. Thank you. Okay, thank you very much. Okay, Ms. Moran, good morning to you, ma'am.
Morning, Commissioner Cantwich. How are you?
I am well, thank you.
Good morning, Tom.
Good morning. How are you?
I'm good. Mike, not used to having the respondents so close at hand here. The petitioner would like to call its next witness, which is John Goldberg, and he'll be participating via Zoom. He should be in the waiting room right now.
Okay. Is that the witness?
That is the witness in the right-hand corner. Looks like we might have some commission staff members. Okay, now we're getting rid of them.
Okay. Mr. Rusconi, can you see?
Okay.
You can? Okay. And you can see? Colonel, you can see, everybody can see. Okay, thank you. Sir, I'm just going to ask you to stand up and raise your right hand, please. Sir, do you solemnly swear under the penalty and penalties of perjury to tell the truth, the whole truth, and nothing but the truth of these proceedings?
I do.
Okay, sir, thank you very much. Okay, the witness having been sworn, Ms. Moran,
Thank you.
please proceed. No, thank you.
Good morning, sir. Would you please state your name and spell it for the record?
My name is John Goldberg, JONGOLDBERG.
And Mr. Goldberg, is my volume sufficient? Can you hear me clearly?
I can.
Thank you. Mr. Goldberg, could you please describe briefly your education after high school?
I hold a BA in journalism from New York University, as well as an MBA from the same school.
Thank you. Mr. Goldberg, are you currently employed?
I am.
How are you employed?
I am president and CEO of my own company, Reputation Architects.
When did you form that company? What year?
2009,
Prior to 2009, were you employed?
I was.
And where were you employed?
Immediately before starting my firm, I spent 5 years at the international communications consultancy Porter Novelli as head of their reputation and crisis management practices. Prior to that, I spent 11 years at Edelman, which is currently the world's largest PR firm. Most of that time, I was the US head of corporate reputation and crisis communications. Prior to that, I was with a unit of the J. Walter Thompson Company for about 4 years. And prior to that, I was at Prudential Insurance, which is now Prudential Financial, for roughly 6 years.
And in those employments that you've listed for us, did you perform any work regarding reputation management?
Reputation management has really been the consistent thread in my work for more than 35 years now. Yes.
Mr. Goldberg, do you belong to any professional societies or associations?
I do. I am a member and hold and have held board responsibilities for the Public Relations Society of America, or PRSA. I am also the US representative of the International Association of Risk and Crisis Communications.
Okay, let's start with is it the PRSA?
Correct.
How long has the PRSA been in existence?
Since shortly after World War II, their organization is celebrating its 75th anniversary this year.
How long have you been a member of the PRSA?
Continuously for about 13 years. I had been a member previously, earlier in my career, then for a variety of reasons, was not a member, just due to other priorities. And then I became a member once again when I started my own firm.
Are there any benefits to being a member of PRSA?
PRSA provides networking opportunities. They provide professional development opportunities for people at all levels of the PR and communications profession. I also speak frequently at PRSA events, typically on online reputation and crisis management topics. And I also write for PRSA's blog and for their monthly magazine, Strategies and Tactics.
And are you familiar with something called the Counselors Academy?
I am.
And what is that?
Counselors Academy is a professional interest section of PRSA. We have about 400 members who are all owners and senior leaders of public relations firms, such as myself. And I've been a member for 13 years and am the immediate past chair of the Academy.
Okay. Have you held any other roles in PRSA or in the Counselors Academy that you haven't described?
I recently concluded 5 years as a board member of the PRSA's New Jersey chapter. I have also been national co-chair of PRSA's Civility Task Force.
Thank you. And I think you also mentioned something, is it the International Association of Risk and Crisis Communication?
That's correct.
What is that?
That is a relatively new organization formed earlier this year by a longtime colleague of mine who's based in Europe. And it emanated from the realization during the COVID pandemic that governments and organizations were in need of wider and deeper resources with respect to improving the way they communicate with their constituents about health and other international risks.
Mr. Goldberg, are you being paid for your testimony today?
I am.
And how much are you being paid an hour?
$450.
Dollars?
Correct.
And I think you said earlier, overall, how many years' experience did you say you had in the field of reputation management?
More than 35.
How do you define reputation?
Very interesting question. Reputation, I'm sorry?
Yeah, just hold on one second. There was an objection. Yeah, Ms. Bourgeois.
The reputation subject in this case is not a corporation with an online reputation. It's not a company in crisis. It is in fact an individual who had no public persona and no online presence. We need to hear this expert's experience with that type of clientele before he gives any testimony, I think.
Okay, well, you haven't offered him as an expert yet,
No, I
correct?
have not.
So once she offers as an expert, then I'll hear from all the parties. Okay, thank you.
Would it please the court, would you like me to offer him as an expert now based on the qualifications and his education that he's outlined?
Well, you heard what Mr. Bourgeois' concern is, so you might want to ask him some questions along there, so.
All right, well then, I'll carry on.
Okay.
Mr. Goldberg, I think we left off, I asked you, how do you define reputation?
Reputation is the set of beliefs or opinions that people form about someone or something. It's a subjective view that one forms. It can be about a person, a company, a brand, a product, a service. In the case of an individual, reputation is how one is viewed, perceived within their social circles, within their community, by their coworkers, their neighbors, their faith community, should they have one, even by their family. And it's based on subjective perceptions of a person's character or their moral fiber, their past actions and behavior, their reliability. Do they do the things they say they are going to do? It could be their skills or abilities, or any combination of those things.
Mr. Goldberg, at Reputation Architects, can you describe what type of clients have you had?
I work with individuals as well as companies and nonprofit organizations, so it really spans the gamut.
And where is your headquarters?
Roseland, New Jersey,
And where are your clients located geographically?
all over the world.
Have you ever had clients from the state of Massachusetts?
I have.
Have you ever had clients who had been arrested?
Yes.
Have you ever had clients who made embarrassing statements that were made public?
Yes.
How do you define reputation management?
Reputation management is a set of strategies and techniques that are designed to strengthen or build, fortify, protect, or if necessary, restore the reputation of an individual or corporation. In the case of building it, very often that is focused on building their online presence in a positive way, so that is how they will be perceived with corporations. Corporations also do this all the time through thought leadership activities, speaking, media relations, corporate philanthropy, social responsibility, and so forth. But these things are all directed toward building and enhancing how they are seen by their stakeholders, whether that's an individual stakeholders, such as their prospective employers, or corporate stakeholders, which could be customers or investors.
What is reputation repair?
Reputation repair, I prefer to say restoration, are things that we can do once an individual's reputation is damaged, particularly once negative information has appeared about them online. In many respects, reputation is a form of currency. So when someone has a positive reputation, when they're viewed favorably, good things happen. Their earning potential increases, their job prospects are broader, they get promoted, they're sought after in their communities. When reputation is damaged, for an individual, it affects a lot of things in a negative way. Their ability to engage in a trade, to get a date, even adopt a pet, as I learned when I rescued a puppy a few years ago and was subject to a rather extensive background check. And the puppy is now 5 years old, I'm happy to say. So that was successful. When reputation is damaged, the goal is typically to suppress negative information that appears in search engine results, often referred to as Google, although there are other search engines that are commonly used as well, by creating content and using other techniques that suppress those search listings so they are less prominent and more difficult to find.
You said other techniques. Can you describe what those other techniques are?
It could be, in the case of an individual, having them engage in community activities or, join a local nonprofit board. And we would help them seek opportunities for positive publicity about what they are doing. The goal being that over time, as they start to build more positive coverage about the things they have done, over time, the hope is that that will begin to push down some of the negatives that are appearing on the first page of Google.
And I saw you were doing a motion with your hand, push down. Can you just describe, a little clearer? What do you mean by push down the results?
If you search for anything online, the first thing you see is a first page returned by Google or the search engine of your choice, be it Bing or something else, which probably has 9 or 10 entries on it. And these are the 9 or 10 entries that the search engine algorithm has determined are responsive to what you are searching for, what you have typed in that search box, and represent the most authoritative and most accurate sources of information, because the search engine algorithm is designed to serve up to you the best information that answers whatever it is you are looking for. Once those initial search results are negative or largely negative, typically it is very difficult to create additional internet content in high enough, in authoritative enough publications and on authoritative enough websites that will push the negative ones off that first page. This has to do with something called domain authority. If an individual is subject to news articles in prominent newspapers, the Boston Globe, the Herald, the Worcester Telegram, for example, because those are newspapers, those are recognized media outlets, they have very high authority and very high credibility from the standpoint of search algorithms. For an individual to create a presence online, it is virtually impossible to create one's own presence on websites that rise to that level of authority. And there are ways to measure that authority numerically. Domain authority is measured on a scale of 0 to 100. The goal is, in order to push down those negative news items, that would require creating additional positive content about the subject in news outlets and on websites that are equal to or higher in authority. And when you put out content and deliver content that Google recognizes as higher in authority, it will rank higher. The more of that you create, the less space there is for the lower ranking negative content. And over time, it slips to the second page of Google and the third page of Google.
Thank you. I think earlier you said that you had had clients at your firm who'd been arrested. Is that correct?
Correct.
What happens when police reports are made public?
Could I have the question
Objection.
again? I didn't hear it.
Excuse me?
I did not hear the question.
Yeah, can you just repeat the question, please?
Certainly. What happens when police reports are made public?
Objection.
What's your objection?
I don't think there's any basis for this, for expert testimony on that subject.
Okay, okay, that's all.
Would you like me to repeat the question, Mr. Goldberg?
Please.
Before he does.
Sure,
just-
oh, sure.
Aren't we getting into an area where this does reflect expert opinion?
Yeah,
But he
you know,
hasn't been
I
hasn't been offered as an expert.
I know, I was just waiting for her to
Okay.
do it, and we are, I agree with you, we are getting close, if not over the line,
Yeah.
so I agree with you, I was just waiting for her to do it, so, and then
Your
waiting
Honor,
for
I'd like
someone to
to-
object.
I'd like to offer Mr. Goldberg as an expert in repair management.
Okay.
May I be heard?
Well, everybody will be heard, sure.
We still have not established that this witness has any experience dealing with individuals who do not have a public persona, do not have an online presence, and the reputation to be restored is back to anonymity. It's undisputed here that the subject was a young woman, no public persona. She had 2 arrest records, the first arrest record, and then she picked up a second one. I don't think there are a lot of, drug addicts that can afford $4.50 an hour. I'd like to hear what he's done with people who have hired him to return to anonymity and have no online presence.
Can I join in, Judge?
Sure, absolutely, everyone will be heard, sure.
I mean, we haven't established yet who he's talking about in conjunction with what Attorney Bourgeois said. Are we talking about Judge Bebo? We're talking about his daughter, whose reputation is being restored? I'm assuming that it is Ali Bebo, and it's exactly what he said. And as far as the actual restoration, what is it that existed before this? What awareness does he have of it before he can even comment on whether or not it was damaged and or restored?
No, it's, I take it that he's not talking about the young lady in question here, as, he is not.
Not yet.
Yeah,
I
no, he
wanted
will,
to-
yeah, at some point, yeah.
First, I would like him to be qualified as an
Sure.
expert.
No, I
And
understand.
I guess that my response would be that the things that Attorney Bourgeois has brought up would be for cross-examination, and that it might go to the weight that his testimony is given and not to whether or not it should be admitted.
So I appreciate that. Mr. Kiley, what do you have to say?
This witness has been proffered as an expert in cost. The cost of rehabilitating an individual's reputation. The individual here, as described by my brother, is an individual who's a public figure who doesn't have the dollars to go out and hire Mr. Fortune 500. And there is going to be no testimony, I've not heard any, as to his experience dealing with such people. I do not think he is, and their reputations, I do not think he is qualified to testify as an expert on the subject on which he is being called.
I appreciate that. Sconey, you want to be heard?
At the risk of sounding redundant, I agree with all the points that have been made. It doesn't seem like it's an apples to apples situation. She does not, obviously, she's not a public figure. It doesn't appear he has the time and experience dealing with someone who is basically in anonymity until this incident happened. I don't see correlation out and see how it's gonna be.
Okay, I appreciate that. A very fertile source of cross-examination, but you can testify. And your objections are noted.
Judge, could I just add one other thing?
Absolutely.
Can we establish whether or not he's ever been qualified as an expert in testimony before a federal court, state court in Massachusetts, or
Sure.
a tribunal such as this? I
Well,
mean, doesn't that go to his ability to testify here?
Well, I can do one of two things, and I'll defer to the parties. Not uncommonly, someone will offer, someone is an expert, and the hearing officer or the judge, at that point will say, do you wanna cross-examine him on the expert? And then, you know, I would allow that. If you want me to do that, I'll allow that. Or we could, you know, I could accept him, I can accept him to bene perhaps, and then you can cross-examine him on everything. So I'll defer to you folks what you want me to do.
It reminds me of my cousin Vinnie, when
Okay.
she's being examined on her automotive expertise
Sure.
as an expert.
Yes.
But I think using that, don't we have to go there to see what his qualifications are in terms of prior expertise and in terms of being evaluated by a court or accepted by a court?
Yes, well, you know, what I'm indicating to you, I'm inclined to admit it. I may admit it to bene if you ask me, but if you want to ask him questions at this juncture just on his qualifications, I'll allow it. But it just seems to me, it's just more expeditious to just leave that for cross-examination. And perhaps to meet the parties halfway, I'll qualify him as an expert de bene, subject to you asking me to return to that decision.
Well, Judge, I just think it's incumbent upon the petitioner to elicit that information,
Okay.
not us.
Okay,
At least initio, ab initio, to have that information put forward.
okay, well, let me ask, could you ask him some questions along those lines?
Which lines are those?
Those slates quickly fading lines, so Mr. Burke, like, can you just indicate what additional questions should be asked?
Whether he's been qualified as an expert in this area of so-called expertise
Okay.
that he's going to be testifying on.
Okay,
In particular, Judge, in Massachusetts courts, so there is a standardized approach to what his testimony is going to be.
okay, I appreciate that. You can ask him whether he's been qualified.
I would add, if I were looking,
Just why don't we do it one at a time? Let her ask that
okay.
question, because then we'll all forget that, and then you can stand up, so.
Can I
Yeah.
suggest a question?
In 1 minute, let him ask this question, and then we'll get to Mr. Kiley, and then we'll get,
when, Your Honor.
okay, go ahead.
Thank you. Mr. Goldberg, have you ever been qualified as an expert in repair management to testify in a court?
I have not. I am sought after for that testimony, but I have not.
Right after, I have not.
Okay, well, that's overruled, he can, okay, next.
Me,
Now, I'm going to ask Mr. Kiley what he,
you go to me first, Your Honor. So from my perspective, I'd like to know, I'd like the witness asked, or possibly by Ms. Morong, when the last time is that he represented an individual who was not here, who had no public notoriety prior to an event, and charged that person money in order to rehabilitate a reputation following an arrest. Mouthful. I wanted to get it all out.
no, it's, I appreciate it, and
The experience that we've heard all relates to his involvement with corporate America.
okay.
I would have added, has he ever represented a person or worked on a case where there was no Google presence at all?
Okay,
Forget hierarchy, there's no evidence in this case that Ali Bebo was known to Google.
okay, what I'm gonna do, because I think it's just the quickest way to do it, I'm gonna qualify him as an expert de bene, subject to your cross-examination, asking these very questions, legitimate questions, candidly, that you've brought up. So I prefer you asking him rather than then ask the petitioner. So with that,
Pardon me, I just want to make sure that I understand the process because this is a little new to me. So I'll do my direct exam, the cross-examination will happen. At that point, you'll make a decision whether or not he's qualified. If you find that he's not qualified, will I have an opportunity to go back in?
yes,
Thank you.
yes.
And I'll ask the court reporter, is it possible to go back to the last? Thank you. Take your time.
When police reports are made public.
I'm sorry, I didn't hear that question.
Question, what happens when police reports are made public?
Very often, nothing. It depends on the state. In some states, police reports are more accessible than in others. Newspapers very often have reporters who are going around to the courts to view police reports just to see what has transpired in the last day. And they may go through a stack of arrest reports, and if something jumps out at them as salacious or juicy or particularly novel, that would likely be the one that they would take and say, gee, this is something my readers will be interested in. I'm going to write something on this, or I'm going to turn this over to my editors. But very often, if an individual is arrested for whatever the crime, if it's not a notorious case, it's one of perhaps hundreds of arrests in a given jurisdiction, and police reports arrest reports all look very similar to reporters, unless there is something that jumps out at them that makes that report worthy of a further look and a potential news story.
If for some reason a police report is publicized, for instance, on the internet,
Mhm.
What are the possible effects of that?
Objection?
Are you objecting?
Yes, I am. There's no evidence in this case that that would have happened, that the police report would be publicized. It's important to remember is at the point where the respondents are, in this case, are charged with acting. We have an arrest, we have an impoundment, that's all we've got. And there is no evidence of a likelihood of publication.
Yeah, no, I'm going to overrule that because as far as I can see, that he's just generally testifying. We haven't brought it home to this case yet.
I want to make one point with respect to this. It's vocabulary. Police reports and public statements of probable cause. What is a public record in a police station and what is not a public record in a police station is not the same as what might be available in a court and is not controlled by by that is an issue in this particular case. There is a confusion that is rampant in the way the case is presented with respect to what an arrest report is, what a statement of probable cause is, and what a public document is. And the conflation is damaging, frankly.
No, I understand that, but he can answer these questions. In my view, Mr. Morang has not brought it down to the facts of this case. He's just generally speaking about, his subject matter. So,
Your Honor, I would also just point to stipulated exhibit number 1. The heading says arrest report, and that's what's leading me to use the language that I am.
Okay.
That was police report that we were just talking about, Your Honor.
Yeah, no, I appreciate all of this, but Ms. Morong asked the next question. Maybe just return to the question rather than have the poor court reporter go all the way back in her record and repeat it. So,
Arrest report is published on the internet. What are the possible effects of that?
Well, typically, there are some ways an arrest report itself could be published on the internet. More often than not, it would be encapsulated in a news story or some other sort of piece of content that winds up on Google. A negative news story about an individual and their conduct, their character, their violation of the law could have an impact on their ability to get a job, on their future earnings potential, on their standing in society, and how they are viewed within their own social circles. It can impact their ability to obtain education. The first place people go when they hear or meet someone, hear about or meet someone new is typically you go to Google and you search for their name. And what comes up on that first page of Google very much influences the opinions people form and the opportunities, employment, education, community, otherwise, that they'll present to that individual.
And can this be repaired once an arrest report or a story that refers to an arrest report is online? Can the person's reputation be repaired?
It can. Typically, it can be improved. One of the counselors made the comment about returning to anonymity. You may have heard the line, "The internet is forever." There is no returning to anonymity on the internet. Someone may not have a vibrant or fully formed or comprehensive reputation on Google, but if they have a Facebook page, if they've ever tweeted, if they have Instagram or Pinterest, they are known to Google. That is being tracked by the algorithm, and that is showing up. Again, it depends on where they start, and in point of fact, for an individual who has no public profile to speak of to start, or a benign reputation online, if you will, it is actually much more difficult to restore their reputation and reverse any damage once it is caused, once it occurs. For the reasons I stated a few minutes ago, typically that negative information shows up on websites that Google's algorithms consider authoritative, that have high domain authority is the term we use. And it is difficult for someone who doesn't own a newspaper to, right out of the blocks, create a website or create content that will rise to that level and have any hope of pushing down and making that negative content less visible.
And Mr. Goldberg, do you have any experience helping or have you ever had any clients that have come to you that don't have an online presence?
Yes.
And what types of services did you provide to an individual with no online presence?
In one case, for example, and this is the most recent case, it was an individual who was accused of fraudulent behavior by an employer and terminated. he found his future job prospects to be essentially nil within his chosen area of skill. And I worked with him and guided him to create some articles that really addressed his competency, that spoke not to defending anything that was out there, but to provide his insight and deliver a sense of how he thinks and the expertise he has in his particular area of experience. And as we worked together and he created these articles, they began showing up on Google on the front page, alongside, to start, those negative news items about him. So at that point, at least employers, prospective employers, were able to get a much more balanced view of who he was, how he thought, what his experience was, what he could deliver for them. And over time, beyond that, the more positive content he created, he was quoted in a few publications relevant to his area of expertise. The couple of negative news items in fairly high-ranking publications slowly moved down to the bottom of the first page of Google, and one has now slipped to the second page, where it is far less visible.
And Mr. Goldberg, how long did you work with this person?
That was about a year and a half.
And what did you charge that person for your services?
My minimum fee, which is what I charged him to start, is $10,000 a month. It did not require 18 months of continuous service, so it would be incorrect to say I charged him $180,000, but it was close to six figures.
Are you aware of prices in the repair management industry?
In reputation management, yes.
Yes, thank you. And is there a range of costs in reputation repair?
The range of costs is typically driven by an individual's seniority and experience and expertise in what they do. A mid-level person working for a large PR agency, say at a vice president level, who specializes in reputation management, is probably being billed, depending on whether they are in New York or Kansas City, between $300 and $400 an hour. More senior people are billed at substantially higher rates. It's very similar to the way law firms work. First-year associates are billed at a particular rate that reflects their experience, while partners are billed at much higher rates.
Are there any cheaper options?
Not that I would ever recommend. And by that, I mean, there is an industry on the internet of people who, consultants, they call themselves reputation repair consultants, which is why I avoid that term, who promise the impossible. They promise, and I've written extensively about this, they promise to be able to erase things from Google instantaneously.
Just let me finish his answer. Just finish your answer, Mr. Goldberg. Just finish
I'm
your
sorry.
answer.
Yeah.
Just finish your answer. And I'll hear Mr. Berman.
They promise to have special techniques or legal abilities or proprietary technology to erase things from Google instantaneously. That does not happen. That does not exist. And they charge anywhere from a few $100s to, unfortunately, I've seen cases where they've charged people tens of thousands of dollars, and ultimately left things, left these individuals even worse off than where they started.
Okay, Ms. Burke, did you want to be heard?
finish his answer, Judge. I mean, at this point, how is that relevant to what
Well,
we're talking about?
you
I know
know-
you have an open-ended evidence coming in, but we're pretty far afield now, when he's talking about some other area of less than honorable reputation repair individuals.
Well, I'm assuming that Ms. Morang is gonna bring it home soon.
I hope so.
Go ahead.
Madam Legal Advisor, I'd like the witness to be shown stipulated exhibit number 1.
Just for the record, so everybody is very clear, what is that?
It's the arrest report.
Thank you.
Goes to the,
Oh, you want me to?
I'm sorry, that's right, the witness isn't here. Sorry, Arthur, can you screen share?
Yep.
The stipulated exhibit number 1?
Can I just second?
Sorry about that,
No, quite all right.
I'm giving it to you.
Okay, I saw it briefly, but it has disappeared.
Hold on one moment, we're experiencing technical difficulties.
It's back.
It's got personal information redacted. That's what the stipulated,
Comments with that.
no.
No.
Turn to number 1.
Stipulated exhibit number 1.
Your Honor, I am going to object to the sharing of this document on the open air. It contains the statements that I suggested to you yesterday. It contains the redacted, the statements unredacted. The publication of those things, in my view, is inconsistent with standards for withholding information that I cited to you yesterday. We have numerous provisions to avoid just this kind of thing from being shared publicly, and I object to it being shown to the general public.
Actually,
Yeah, sure.
further to that, my memory is that part of the Supreme Judicial Court rule on disclosing confidential information, that based on that, virtually all prior public adjudicatory use of that document least excluded the photograph. That does not exclude the photograph. And I don't understand the basis upon which in the district court, for example, the photograph would be blanked out or removed if anyone went there to look at the public record. But here it's to be displayed publicly. I don't think that's appropriate.
I find it interesting because it would seem to me that the petitioner would be making those types of arguments. Yeah, go ahead.
Judge, this is simply a re-victimization of Sally Bebo and her
Yeah.
father. It's grossly inappropriate. He can look at it, he can refer it, but you put it up there in a public venue, you're just reiterating what everybody should have the sensitivity to.
Okay, well, no, I appreciate that, obviously. No, the problem is the witness isn't here, so he can't be handed something. So,
It's a stipulated exhibit, Your Honor.
And
so it is.
he may already have it, Your Honor.
What's that?
He may already have it.
Does he have it already?
I don't,
But, it is a
it's
stipulated
stipulated
exhibit.
by all parties.
It's out there. So, I appreciate what you want me to do, but it's out there. So,
I'll certainly keep the publication of it to a minimum. I'll ask the witness if have you had an opportunity to look at what is stipulated exhibit number 1?
I can see the top of one page, yes.
Can you just scroll down? Thank you, Mr. Shah. And when you've seen the entire thing, please look at the camera.
do you want to draw his attention to something?
No,
You're
I
just
just wanna
asking him
make
to
sure
take a
that
look at the entire
I'm
document?
just asking him to identify this, that he's seen it.
We
And-
don't need to publicize it for him to be able to say, yeah, I've seen it.
He's reading it. Just give him an opportunity
I'm
to.
asking.
Well, it's going by very quickly.
Okay, well, I'm just gonna let him read it, and then you can ask whatever question you want to ask.
Thank you. I'm sorry, Your Honor.
I should know for the record, he's reading, it's not seen on the screen right now.
Which was,
Arthur, can you
Is it?
confirm whether or not this document's being seen by the public?
It is.
that's the objection, Your Honor,
That's-
and it's inconsistent with
Well,
the
you know,
law.
the bottom line, it's an exhibit. So it's in there, so it's an exhibit, it's in there, she can ask him questions, and it's a stipulated admitted exhibit. So go ahead.
Mr. Goldberg, have you seen that document before?
I have.
And I'd ask Mr. Shaw if he would stop publishing the document to the witness.
Does he have a copy of this? Did you furnish him with a copy of this, Ms. Moran?
I did, but for purposes of the record, I wanted to establish. Thank you. Mr. Goldberg, I just had you look at stipulated Exhibit 1. Had you seen that document before?
Yes, I have.
And based on your education, training, and experience, have you formed an opinion as to the cost to repair the reputation of the arrestee or her father if stipulated Exhibit 1 was made public?
Objection.
Look, I'm gonna let him,
May I be very brief?
yeah, absolutely, go ahead.
The question is, what is the baseline to which you would restore? In other words, the fact that the public may know that she's arrested is different from the fact that the public may know the details of the report that we just published, okay?
Okay.
So we can't talk about a cost to restore until we know the baseline we're trying to restore it to.
Well, as I said, all fertile questions for cross-examination. So, yeah, go ahead, Mr.
The
Burke.
judge, what he's being asked is to restore it as it exists in the original format. What happens is it's impounded and it's redacted, so the issue isn't what on there. A court legally impounded it from public view, so it's a different question that should be asked.
Okay,
It's the content of the arrest facts as opposed to the extraneous, as he described, salacious ingredients that are in there that are removed hopefully by the court's impoundment.
I totally sympathize with what you're saying. You can answer the question, and your rights are saved, your objections are made. Go ahead, Ms. Moran, why don't you re-ask the question, or you're gonna have the court reporter.
I actually would ask the court reporter. It was a mouthful.
Question, and based on your education, formed an opinion as to the cost to repair the reputation of the arrestee or if stipulated Exhibit 1 was made public.
I'm sorry, could you read that a little bit louder? The audio is dropping out a bit.
Question, and based on your education, training, and experience, you formed an opinion as to the cost to repair the reputation of the arrestee or her stipulated Exhibit 1 was made public.
Yes.
What's your opinion as to the cost?
Based on what I have seen online, the impact on the reputation of both Ms. Bibot and the judge, it is not recoverable. They could spend tens of thousands of dollars attempting to make things go away. It would not be enough. Because when I look at the first couple of pages of search results, which is what anyone sees if they search for the judge's name or his daughter's name, the majority of search results are related not necessarily to the arrest itself, but to the actions taken with the arrest report. And those are all in highly credible media outlets. And I did look the other day, this could have shifted very slightly by today. The Boston Globe is a domain authority of 91. That is on par, close to, not quite, the New York Times or the Wall Street Journal. The Boston Herald has a domain authority of 86. Those are not likely to be influenced by anything that could be done, any techniques that are available to enhance or restore either of those reputations.
And I just want to make sure that I understand your response. Is your response based on the arrest report that's been marked as stipulated Exhibit 1, or is it based on the conduct of certain individuals that acted regarding stipulated Exhibit 1?
Objection.
I don't quite understand the question, candidly.
I think she can ask the basis, but I don't think she should be suggesting what the basis might be.
Well, maybe make it real simple. The objection is sustained. I'm not precluding you from asking questions in this area, but in that form, it's sustained.
And the opinion that you just stated, was that based solely on the contents of stipulated Exhibit 1?
Objection.
I'm sorry, do you want an answer? I thought I heard
Yes.
something.
Yeah, please.
That is based on my assessment of the damage that has been done to Ms. Bibard's reputation and the judge's reputation, based on what I see online, which ultimately was created by her arrest and everything that transpired after that. I could not look in isolation at an arrest report and say, if this got out there, this is what it would require to rehabilitate the arrestee's reputation, because from just a police report, I can opine on what might occur, but until news outlets and reporters and other parties, bloggers, et cetera, do something with it, it has not had a material impact on reputation, or as I said, if the report itself somehow were to be findable online. But just based on a police report or an arrest report, I can't quantify the damage until that damage is done. And until I quantify that damage, I can't speculate on how many months and how many thousands of dollars it would take to address it.
Can I have just one moment, Your Honor? Thank you.
Thank you.
Thank you, Your Honor. Mr. Goldberg, what would you tell Miss Bebo or her father if they came to you for advice?
Objection.
You can have it.
Judge, this is so speculative. What would he tell them? First of all, he hasn't met or he doesn't know the first thing about them. They haven't sought his counsel.
Oh,
I mean, it's a
okay.
hypothetical, speculative question.
No, I appreciate that and all. Subject to fertile cross-examination. What do you want to say, Mr. Bourgeois?
The witness just said, I believe, that but he can't quantify any value because of the effect of the mixing of police report with the other activities that were alleged, okay? In that situation, the question, what would you tell the Bebos, is not meaningful. The operative question is whether the actions that are alleged of the respondents had substantial value. At that time, she was a relatively anonymous person. The question that they're asking now mixes two important things that need to be kept separate if the commission is going to make a fair decision here.
No, I appreciate that. And as I said, I expect all this to be brought up on cross-examination. He can have the question.
You need me to repeat the question,
Please.
Mr. Goldberg?
Please.
Ms. Bebo or her father came to you for repair, for reputation repair. What would you tell them?
You know, typically someone comes to me because they are concerned about what's being seen on Google. They will tell me their situation, what has happened, and they will give me a hint on what to search for on Google so I can look and see what it is they are asking me to deal with. Had they come to me with that situation, and had I looked at Google, I would have had to say that their reputation is essentially irreparable because of the magnitude of what is out there and because of the authority and credibility of where that negative information appears.
Just one more moment. And further, thank you, Your Honor.
Okay, following up on Mr. Bourgeois' earlier request to take a break at this juncture so the parties can consult, I'll be happy to take a break now. How much time do you need? I don't care how much time you need, just tell me how much time you need.
15 minutes?
15, 20 minutes, Judge.
Okay, so absolutely. Okay, so I'll be down in about 20 or 25 minutes.
Your Honor, are we having the witness stand by on Zoom? Are we gonna put him in a breakout room or something?
Well, why
I
don't
can
you explain
stop.
to him, why don't you explain to him what's happening and then logistically you
I
folks
just
can
wanna
get it.
I don't wanna have any contact with him
Yeah,
that's
sure.
outside.
Yeah, maybe we should.
Okay, all right.
The rules,
Take it out.
camera off. Rules.
Yeah.
He turns the
He just
camera
did.
off. Okay.
Thank you. I wasn't familiar with them. Thank you.
That's okay.
We need,
What's that?
we need the witness.
Oh, yeah.
Why? I can't control myself ever.
Hey, okay,
Also, Judge.
please.
Sir, good morning. My name is Tim Burke, and I'm representing Major Anderson. Have you ever met her before?
No.
And during the break, I took the liberty of going back and speaking with our court reporter and asked her to isolate a portion of your previous testimony towards the end of your direct. And during that end of the direct, you said, quote, "I could not look in isolation at an arrest report and say, if this got out there, this is what it would require to rehabilitate the arrestee's reputation, because just from a police report," end quote. Remember saying that?
I do.
That's true, isn't it? Just yes or no?
Yes.
Thank you. So,
Okay.
I'm not planning on asking any questions. I think that frankly, that's dispositive, and I expect one of my brothers to move to strike the testimony.
Your Honor, I do move to strike the testimony on 4 grounds. First, the witness in his own testimony has acknowledged that the opinion that he was asked is speculative and asks him to value something that he says in his own words was impossible. Second, the witness's testimony about the mixing of the arrest report and the publicity about supposed efforts to conceal it or change it demonstrate that not only was there no substantial value, but petitioners just proved that any risk outweighed the value. Thirdly, his testimony is just not grounded in the facts or issues in this case. The question before the commission, they don't help on this, is at the time the matter was impounded, was there substantial value in revising the report? There's nothing that you've heard today about that. What you've heard is there was substantial risk involved. Lastly, the witness is just not qualified to give opinions about arrest reports for individuals who did not previously have a level of anonymity and absence from Google or internet. He's an expert in what he does, but he doesn't represent the Ali Bibos or the Judge Bibos of this world. You should strike his testimony.
Okay.
It's not helpful for any question.
Well, that might be, you brought up an interesting point about, if I may ask a question of have you ever represented, has anyone with this type of person's background ever come to you?
All the time.
With this type of background,
Yes.
Someone who was a heroin addicted sex worker?
So someone who, it could be a parent who comes to me because their college kid or teenager has gotten in some trouble and they don't want that, or something has shown up on the internet. It could be, I'm approached by all sorts of individuals with all sorts of criminal and other issues.
Okay, let's, did you have any more questions? Did you want to ask on redirect?
No, but if there's a motion to strike his testimony, I was wondering if I could be heard.
I'm just gonna, before I hear from you, I'm gonna hear from Mr. Rusconi, because I haven't heard from him yet.
Well, again, I don't want to be redundant, I stand with my
Okay.
counsel and what Mr. Bourgeois said.
Okay,
I do want to follow up with one thing. Again, based on your question, if I may. Good morning or afternoon, Mr. Goldberg. Tom
Good afternoon.
Kiley and I represent Mr. Early. The individuals that you described in response to Judge Kantrowitz's question, do you send them away?
I'm sorry, do I send anyone away who is an individual without a,
Do you engage with them and charge them at your corporate rate?
if I believe I can be helpful to them, then yes, I engage with them. That is the business I am in. If I believe their situation is such that I cannot be helpful, I'm not going to take their money. There are lots of people out there who will, but that's not the way I do business. I have my own reputation to
Of course you do.
manage.
Of course you do. You are not, are you, one of those SEOs that you condemn? You do not do the search engine optimization, correct?
Well, have to be careful because search engine optimization, SEO, is a very broad term. There are two camps. There are those who do it in an ethical way, such as the one I described of creating favorable content identified with an individual. There are those that try to trick or manipulate Google through various technical means. There are even those out there, and there's quite a record of fraud on the court of people trying to get stipulated judgments in order to get Google to de-index things. So there are plenty of, when I work, we don't engage in those things. We work with people, and I've written about this extensively. It's on the internet. We're focused on creating content for people, helping them do things that will be viewed in a positive light and get credit and attention for it.
The situation that you described in your testimony with respect to this matter was that the situation was irreparable. That's your word, correct?
In my opinion, given what appeared on the internet following the arrest, there is so much out there on the first several pages of Google that making a measurable, a noticeable dent in that would be extremely difficult, and it would be impossible, in my estimation, to make that go away, which is why I work with so many.
I think you've answered my.
I'm sorry?
I think you've answered my question. So impossible is also your word, correct?
That is my opinion, yes.
What your testimony is you would not have taken their money, correct?
That is correct, because there is no amount of money they could spend
Sir,
that would.
Sir, please just answer my questions.
Sure.
And in the numerous writings that you have made and the podcasts in which you have participated, it's this very situation, don't you, with respect to what individuals who don't have $100,000 to spend can do, correct?
I'm sorry, restate that, please.
Do you know, you do participate in podcasts, correct?
I do.
And people can listen to your podcasts or read your writings without spending a dime, do they? Can't they?
Absolutely.
And the advice, the conclusion that you would give to some people, as reflected in your writings and your free podcasts, would be the same as the advice that you have been talking about today, correct?
Not necessarily. It would depend upon an individual's specific circumstances.
All right, but with respect to the specific circumstances of this case that you were referenced, you could get it, the bottom line, from looking at a free podcast or a writing that is available on the internet, correct?
I believe I understand the question. I couldn't agree with that, no.
Okay. Thank you.
Your Honor, may I ask a couple of questions
Sure.
based on your question?
Sure.
Can you hear me all right, Mr. Goldberg?
Now I can, yes.
Okay, great. And I'm going to ask you to do me a favor and just, if it's possible to answer my questions yes or no, I'm going to ask you to do that because it'll move things along. Going back to the judge's hypothetical about people coming in and asking you about this situation, isn't it true that the very first question you always ask is, what happens if we do nothing?
No, it is not.
Isn't it true that you gave a podcast to something called Copper State last month, where you talked about the importance of analyzing doing nothing and avoiding what's called the Streisand effect?
Yes, that is correct. I've talked about that.
And isn't it also true that in your business, the Streisand effect is when the efforts to try and change what's out there blow back and make it much, much worse? Isn't that right?
That is what the Streisand effect is, yes.
And so one of the reasons that you ask the question, what happens if we do nothing, is the recognition that most arrest reports go nowhere, and we want to avoid the blowback of adverse publicity claiming concealment. Isn't that true?
I'm sorry, could you repeat that?
Okay. Were you in this situation at the time of the actions of the four respondents in this case? The court had impounded the document that you were shown, the arrest report. Were you aware of that?
And by impounded, just for the sake of clarity, explain what that means.
A court order removing the document from public view so it is not part of the public record of the court proceedings.
Mhm.
Were you aware that that had occurred?
I was aware that that had occurred, yes.
Okay, and were you aware of the situation where it's alleged that the respondents did what they're alleged to have done after a judge had impounded the case?
I cannot say that I'm fully clear on that order of events, but I'm aware that both the impoundment and the allegation that the report was changed.
I'm sorry, I don't understand what you just said. Yes or no?
Yep.
Did you know that a judge had impounded the case at the time of the allegations of action against the respondents? Yes or no?
I was not aware that it had been impounded prior to the further actions.
Okay. Do you agree with me that assuming the fact of impoundment, that the risk of Streisand effect of taking any action outweighed any benefit of trying to change the report? Yes or no?
The risk of taking, I just want to make sure I understand, the risk of taking any action outweighed. I'm sorry, Counselor, I will ask you to ask that one more time.
All right, I'll try and ask it for you differently, okay? You're in a situation in your office and the people come in and ask you a question.
Mhm.
And the facts as they appear to you is someone's been arrested. The arrest report has been impounded. There is no expiration date on the impoundment.
Mhm.
And the question you're being asked is, does the risk of modifying that report, the risk of getting adverse publicity from the act of modification, outweigh the benefit of just doing nothing?
That would depend very much on who my client is. If the Bibauds are asking me, then the answer would be different. If you are asking me whether, if you were suggesting that someone who has an ability to change a police report, whether them doing so creates a greater or lesser risk, if I were counseling them, I would say it creates a substantially greater risk.
A substantially greater risk than the value of any potential benefit, correct?
I think the two are unrelated. The value of the benefit, if you will, can be based on a couple of things. It could be based on the cost of repairing the subsequent damage. It can also be based on the economic damage that damaged reputation can cause to the individual. So, I can't, if I understand the question, the risk can be more or less depending on the circumstances and how that plays out.
Well, we'll try it one more time on a yes or no basis, and if it's not fair for you to answer it yes or no, you let me know, okay?
Mhm.
You have on one hand the fact that you testified that arrest reports, usually nothing happens with them. plus the fact that this arrest report was impounded with no expiration date on the impoundment. Then you have, on the other hand, the possibility that someone might misperceive the motives or reasons why an arrest report was being changed. And that created its own publicity. Isn't it true that based on your own writings of first do no harm, as you've said in several things that you've written, that you would counsel, let's wait and see and do nothing? That's the safer course. Yes or no?
That's not a yes or no answer because it depends very much on who I am advising to take
Okay.
action.
Thank you. Thank you. It's the best we'll get. Thank you. Nothing further, Your Honor.
Okay. Does anyone else want to ask any questions based on that? Do you want to ask any questions?
Just a short redirect, if I may.
Sure.
Mr. Goldberg, Mr. Kiley asked you a question on cross-exam, and I'm not sure if you had time to finish your answer. Why wouldn't you take the Bebo's money?
Because in my view, based on my experience, the damage that had already been done by the news of the arrest and the things that occurred subsequent to that, everything that's happened in between, the cost of making even a minimal or a moderate dent in that damage would be tens, if not hundreds of thousands of dollars with no guarantee of success. And still, there would be reputation damage for her to contend with as her life went on. So, in orders of magnitude, you get rid of half the damage, the other half is still there. It's going to have the same effect on all of the things I've listed that are potentially affected by negative content online.
Thank you. I have no further questions.
Thank you. Does anyone have want a recourse? No? What's that?
Can you give me a second?
Oh, sure.
I do renew my motion, Your Honor.
Sure, no,
Hold on a minute. Hold on.
I'll get to that in a minute.
Regardless, sir, if you would have taken anybody's money, the fact remains your testimony is consistent that you could not look in isolation at an arrest report, the Bebo arrest report, and say that if this got out there, this is what it would require to rehabilitate the arrestee's reputation because just from that police report. Isn't that true? Sir, just hold on a second. This is not a question that requires elaboration. Isn't that true, what you had said at the end of your direct testimony, that you couldn't make an evaluation because simply based upon an arrest report, nothing else?
Yes, that is true.
Okay, is there anything else anybody wants to say? No, yeah, so Ms. Bourgeois, you.
I actually, if I may,
No question in front of you, sir.
Hold on.
fine.
It's okay, hold on. So what do you want to say, Ms. Bourgeois?
I again renew the motion to strike in its entirety the witness' testimony on the grounds that I previously stated. It is, by his own acknowledgement, speculative. He cannot respond to the question, the ultimate opinion that he was asked. There are no qualifications. He's not grounded in this. And I will further I don't understand how he assists the commission with anything, any question that's in front of him. I mean, just an exercise in futility.
Okay, now you Ms. Moran, what do you have to say?
Thank you. I would point to the commission's rules of practice and procedure, and relevant evidence may be admitted, even if it would be inadmissible otherwise under the laws of the Commonwealth, if it's the kind of evidence on which a reasonable person is accustomed to rely on in the conduct of serious affairs, and it is reliable in the judgment of the presiding officer. And I would suggest to you that this is the kind of evidence, that this testimony is the kind of evidence on which a reasonable person could rely on in the conduct of serious affairs. And I would suggest that if there are any issues with Mr. Goldberg's testimony, that would go to the weight that you would give it, but not to exclude it altogether.
May I respond? It doesn't go to the weight if the witness hasn't answered the question. You know, we learned a long time ago that questions are not evidence. Answers are evidence. And the witness didn't answer the petitioner's question. He said, I can't answer. It's speculation. I can't pull these things apart. There's nothing I can do. I mean, okay, you know, a trip to Mars might have value, but that doesn't mean we put in evidence that somebody's going to Mars, because the witness says, we're not going. You can't do it. And they called a witness who quite literally acknowledged, I can't do what the petitioners asked us to do. Testimony should be stricken. It gets us no place. Her recitation of the law is correct, but there is no evidence on which you can ground anything.
Yeah, Ms. Burke.
Judge, can I just chime in? You've been open in terms of whether it goes to the weight of the evidence or its admissibility. You know, just from the beginning, he's never testified or been qualified in any court of law as an expert. Put that aside, the information. So that's just his criteria allowed to opine on something. There's a predicate for it that he's never been qualified as an expert in this area. This is a unique area. And Judge, one of the things you talked about was the substantial value. All right, if you're talking about substantial value, the critical part of his testimony, and you said, well, we're going to get to that. We're going to get to that. And the critical point was when I just had a reporter, got the information, so I was reading it. You cannot put a substantial value on the arrest report as it existed at the time that this took place. It's only the after effect that it's gotten out to the public. That's when it has some effect. But before that, and when it's revised, and until it gets out, it doesn't have a value. That's the important part of his testimony. He can't make the determination. No evidence in front of you of what the substantial value is. He says he can't make that determination just looking at an arrest report. And when you allow the motion to strike, the critical element of their case has not been proven. So whether it's we go through the exercise of calling the rest of the witnesses, or we terminate because this is their evidence on substantial value.
If I may, it's not our only.
Hold on, Mr. Kiley, I'll get to,
To take us back to yesterday and your rulings yesterday, with respect to the other evidence to be proffered, the test here is substantial value of what it is that the respondents would receive, the respondent receives, not the cost, the value. And what we've heard is that there is no value in this case. That's what the testimony has been. To the extent this witness is asked, it is being taken in order to establish value as articulated in the statutes. Not bear on it. And you do have the discretion and it does reside with you as the presiding officer. Grant the motion that has. So,
I appreciate that.
I'm sorry, I'm just not clear which motion Attorney Kiley's talking about.
Motion to strike the testimony.
Okay. I'm sorry, it sounded a little bit like it was a motion to dismiss, and I wanted to make sure I didn't miss
I
anything.
think it's a motion to
I
strike.
think I've made our position clear that certainly of great latitude as the hearing officer, and that it would be helpful to the commission to hear the evidence.
Oh, yeah, Mr. Rusconi.
One final.
Yeah.
Attorney Bourgeois tried in several different variations to elicit testimony as to what the witness would tell someone in the relevant circumstances, specifically to the votes. And we didn't get a specific answer, but it sounded a lot like, in response to the petitioner's questioning a few moments ago, why wouldn't you take their money? Paraphrasing, because there's nothing I can really do. That sounds a lot like evidence that is not going to be helpful to a reasonable person, because to me, in my view, that says it's not gonna be done. There's no value to it, save your money. I don't see how that's gonna assist a reasonable person in the context of the rules.
Okay, that's it. Anybody else want to be heard? I'm not a judge, and while I might be very sympathetic to what your positions are, it's ultimately the decision of my fellow commissioners along with me to make that decision. And while I might be sympathetic to your position, and I'll voice my opinion to my fellow my fellow 4 other commissioners, I'm not going to preclude them from giving whatever weight they want to this witness. So I'm not going to strike it. I'll allow my fellow commissioners to hear it all, and we'll all discuss it, and then we'll give it whatever weight, if any, that they deem wise. So there you have it.
Thank you.
Okay, thank you. Okay, let me ask, who's your next witness?
Our next witness is
Mr.
Chief.
Goldberg be discharged.
Oh, I'm sorry.
Oh.
Yeah, Ms. Goldberg, I want to thank you for your time, so thank you.
You're welcome, and thank you for listening to my podcast.
Wait, can you hold on one second?
Can he stay for a moment, please? Mr. Goldberg, could you stay with us for one moment?
Yes.
Thank you. Just an inquiry.
Okay. My fellow commissioners, some of them are listening to these proceedings and they may have a question. So I think that's what Ms. Duca is indicating. And while she's doing that, Ms. McDonald, you started to say about the next witness.
Oh, I'm-
Ron was,
Oh, I
Sorry,
apologize.
And I just came up here so that everyone could hear. Based on your suggestion that we find another witness for today, we were able, Chief Justice Dolly was very kind to tell us that he would come in today, but I don't know if he'll be able to get here before 2:00. He had to rearrange some things.
So he doesn't want to do it via Zoom?
I don't,
thought he was planning on coming in.
he is coming in.
He wants to come
Oh,
in?
no, he's coming in. I'm sorry, I misunderstood the question. And so is his counsel, and they'll be here this afternoon.
2:00.
Maybe earlier, but I didn't wanna, I actually don't have a watch on, so I don't know what time it is now, so I didn't.
12:30.
12:30. Do we wanna reconvene it? It's Ms. Pruitt's witness, that's why I'm just checking with her. 2:00, please? If we could.
Well, why don't we do this? Number one, it seems to me this would be an opportune time to take a lunch break, because even if the witness was here, we would probably run a little late. So why don't we take the lunch break, and we'll say tentatively 1:30, because he may get here. Well, why don't you just let me know when he gets here, or let us know? I don't want to hold you folks all up too, but it's going to be a minimum of 45 minutes to an hour for lunch. And then let us know whether he's here at 1:30 or getting here at 2.
If I'm able to contact legal advisor Duca, is that the best way to disseminate the information?
You have my cell phone number.
Okay,
You can certainly tell me that. As to disseminate it to the, I don't have anyone's personal cell phone and
Oh,
okay.
don't need a
Yeah. Maybe we could pick a point person because I just don't know, I want to make sure.
If you tell me, I can text everyone.
Perfect, then you and
wanna
I.
make it difficult for everybody.
No, and I just want to make sure.
It's easy to say
everyone
come back
gets
at 2 or
the-
come back
the
at 2,
information at the right time.
but
I just had one other piece of housekeeping for your honor, which is since Chief Justice Dolly has agreed to come in this afternoon, he won't be appearing tomorrow. So based on your request that we perhaps end earlier tomorrow, we've been able to move Trooper Sevier from the afternoon to the morning session
tomorrow,
tomorrow.
okay.
We have, after Trooper Sevier, we anticipate 2 more witnesses. We've inquired and neither one of them can come tomorrow afternoon.
Neither?
Neither,
Yeah, what I don't quite understand, and I don't have, they're under subpoena,
yes.
so I don't quite understand, when you subpoena someone, you say you have to come in. And now they're saying, well, it's kind of inconvenient. I don't quite understand the
They'll
problem.
be here on Wednesday.
What's that?
They'll be here on Wednesday, our next hearing date. They just can't be here tomorrow afternoon and I apologize.
Can I ask to accommodate, when are you gonna call Mr. Keenan?
I think we
To
told
accommodate Mr.
Attorney
Bourgeois.
Bourgeois that we would call Mr. Keenan on Wednesday. We informed him of that this morning.
Okay, so on Wednesday, so theoretically, you don't even have to be here tomorrow if
I have a medical appointment.
I know, so you won't, but with this witness appearing, it's, you wouldn't be really questioning that witness particularly.
No, I would not feel the need to be here for Mr. Screevor tomorrow, so I would probably not show up at all.
Okay, and your client need not show up either, it's entirely up to him.
That's
And then so on Wednesday, we'll get to your case.
Right, my understanding is they're gonna call Mr. Keenan on Wednesday and I will then call Mr. Travis.
Okay, so your concerns should be addressed on Wednesday.
I mean, if I think they haven't put in anything against
Sure.
Mr. Travers, I'm not gonna call him, but okay.
Oh, okay, that's fair enough. So I'm just waiting for Ms. Duca.
if we could have a 5-minute break, so I could sort this out.
Well, is it a question we have to ask him?
It may be, I'm trying to, I
Well,
can't determine from the text, I apologize.
Well, since he's on the clock for $450 an hour, why don't we just try to expedite it now? Is there anything else? Anything else?
I'll object to the questions from the other commissioners if it'll save us some time.
You're free to do that.
I object.
You're free. From the witnesses to the witnesses.
Audio, and then I respond to that,
Uh,
and I haven't received a response, so I don't know what.
I just number one, this is from one of the commissioners, and he states, you may want to advise counsel that they have a hot mic that picks up conversation with their client. So I think Ms. Duca already indicated that, but I just want to just reiterate again. And this is a question that he has. If the events in the arrest report are already known by the public, was there a value to the impoundment of the arrest warrant? I'm not quite sure I understand that question, but the question this commissioner would like to ask is if the events in the arrest report are already known by the public, was there a value to the impoundment of the arrest warrant? I see what he's saying.
And object to that question. The issue of whether there's a value to the impoundment may make sense to Judge Locke, who ordered the impoundment, but he ordered it, and there's no one's questioned the propriety of Judge Locke's order.
See, once again, I'm not a judge in a trial here, so there's certain parameters of what I can and can't do, and I'm probably not gonna, he's a fellow commissioner, he's got a right to inquire. So what do you want to say, Mr.
All I want to say is I'm not sure that's a question for this witness.
Well, what I'm gonna do in deference to my colleague, I'm gonna ask the question of Mr. Goldberg. If the events in the arrest report are already known by the public, was there a value to the impoundment of the arrest warrant? If you can answer that, and if you can't answer that, I appreciate that. If you can answer it, I appreciate that. And after your answer, if it's a substantive answer, everybody can ask follow-up questions.
If the information is known to the public, but then is taken, removed so that it would not have further access or visibility, yes, that would certainly reduce the chances of further media attention or reporters getting a hold of it. So, at any point, if the information is out there, there is a risk. But anything one can do to mitigate that risk by making information harder to find, that has a value.
Okay, based upon that answer, does anybody have any questions?
Your Honor, just one question?
One?
Yeah.
Okay, I'll give you two, Ms. Moran.
Promises from me now.
And Mr. Goldberg, just to follow up on your response, what would be the value of impounding a police report after, or an arrest report after it was already public?
Objection.
But that's not objection, Judge. It's not factually supported by the evidence that are their position or ours. It hasn't, it's irrelevant. It just didn't happen.
Okay, I once again, I respect your comments, but you can have the question.
Answer the question, please.
What would be the value of impounding the arrest report after it had been made public, if I understand?
The way to calculate the value of impounding the arrest report would be to consider the damage that is being prevented. That can be measured in two ways. That could be measured in the fact that doing so would likely limit the amount of media coverage and other attention the contents of the police report would get online. It can also be calculated in terms of, the value of not having her reputation damaged, which goes to the things I discussed earlier, her future earning potential, employability, and all of those economic benefits that you can put a dollar value on. So if her reputation is being protected to some degree by ensuring that as few people as possible see that report, that has substantial value.
So I'm not sure that's the question here. The question, if the events in the arrest report are already known by the public,
Yes.
so is there any value of the impoundment? So I think what the commissioner is saying, if everybody knows the events of the arrest warrant, what's the value of the impoundment of a document that everybody already knows about? That's what I think which frankly, it seems to help the respondent's position. But, I'm just,
Well, I like all the hope I can get, Judge, but that's again, it just actually isn't supported by the evidence.
Yeah,
I mean, it was never made public before the impoundment took place.
Yeah, but as I'm saying, it seems to me this answer helps you. If the events in the arrest report are already known by the public, everybody knows what's in the arrest report, right? And then they impound it. Is there any value to the impoundment of something that everybody already knows? So the obvious answer, it seems to me, would be no.
I withdraw my objection and I appreciate,
Impounded, Your Honor, is the case file.
What?
What was impounded was the case file, not the arrest report itself that is entered in Rams is not impounded, never was impounded. So the idea here is, and we have laws that deal and rules that deal with impoundment in order to prevent that which occurred. So the facts, there'll be no testimony, as you posited, that the arrest report, the thing that was originally written and rejected by Sergeant Conant, and then written again, there will be no evidence that that was known prior to the impoundment order, which happened on the morning after Ms. Bebo's arrest. So the foundation is just not there.
You know, I understand all the technical arguments. All I'm saying is that this seems to be a question that's very favorable to the respondents, and I'm going to give the petitioner an opportunity to, if she wants to ask any questions to clarify that, or
No, nothing further, Your
I
Honor.
think it's pretty self-explanatory.
Thank you.
So is there anything else at this juncture? No. Okay, so we'll see you. Why don't we say we'll tentatively see, I'll see you back here at 2:00 unless you hear from somebody saying the good judge is here earlier, but I'll see you at 2:00. Yeah, and hey, Ms. Goldberg, thank you very much, sir.
You're welcome.
Wait, hold on. Oh, my God. Yes.
Oh, is he gone?
Yeah,
He's gone.
Okay, he's gone. Okay. This was another question, and he came. If respondents had not taken any steps after impoundment, would you have advised family to hire you and take steps, and what steps? So he's not here to answer that question. Perhaps final argument, you can address that. That's obviously a concern. That's obviously a concern for one of the commissioners. With that, have a good lunch, and I'll see everybody back here at 2:00. Thank you.
And then I'll fill a few. I'm going to ask you to take administrative notice of rules of court and other materials that I might use with this particular witness.
Okay.
I'm going to start with the Uniform Rules of Impoundment, which is Rule 8. I have my book from 2017. I have a copy of that particular rule for you.
Okay.
I think we've all.
That's the document Mr. Travers is going to expect to have.
Oh, okay, great. Okay, good. Okay, thank you.
I'm going to ask you to take the Uniform Rules of Public Access.
Okay.
Again, applicable time, and in particular, the addendum at the back end of it, which deals with things confidential.
You'll make my life a tad easy if you can just give us copies of this. Is that going to be a
I gave
problem?
all of my copies to everybody else. I will give you copies.
Okay.
But I want to put this on the record that I'm asking for it now. I am also going to ask you, this would be the one document that came later, but there may be testimony from this witness that might pertain to it. It's Standing Order 19 that deals with electronic applications for criminal complaints. The witness may indeed offer some testimony with respect to it. Also, uniform for probable cause determinations, arrest for persons arrested without a warrant. That's Trial Court Rule 11. All of them Roman numerals. And in the time frame of 2017, what was applicable on complaint procedures, a set of rules, standards published by Chief Justice Connolly, 2008, dealing with revised standards on the complaint procedure. And if I inquire with respect to it, it will probably be with respect to the last two particular provisions, that voluminous document.
Okay.
I will provide copies for your consideration later.
Okay, fine, that's no problem.
That's all I can fill.
That's fine. Does anyone else want a preliminary be heard on anything? Okay. I know it's Mr. Travis is back. Good afternoon. Yeah, so just get us copies at your convenience. Okay. So is the witness here?
Should I reserve any objections to those documents in the event that they're relevant, or as Mr.
Well, you know, if you take,
indicated, at least one of them was not within the timeframe, the relevant timeframe?
you know, well, you can do whatever you want to do, obviously. He's just asking me to take it, you know, judicial notice of pre-existing documents, you know, what weight to give it. And if you say it's inapplicable, yeah, just save your argument for whenever you want to argue. Okay, so thank you.
I wasn't planning on offering them as exhibits as such.
Okay,
If you're gonna take administrative notice,
I'll take it, you know,
we'll see.
so, okay, do we have the witness here?
Yes.
Thank you.
The petitioner calls Chief Justice Dolly. If you could sit right.
So before you sit down, Chief, let me just ask you to raise your right hand. Do you solemnly swear under the pains and penalties of perjury to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. The last time I saw Mr. Connolly, I was a judge presiding over a murder trial. You were the young assistant district attorney, and it was Willie Davis and Bob Jubenville were the defense attorneys. It was a great trial, and I'm glad to say you haven't aged at all.
I wish it were true.
Okay, so, okay, please proceed.
Thank you. Good afternoon, Chief Justice.
Good afternoon.
Could you state your full name for the record and spell your last name?
My name is Paul Dawley. Last name is spelled Dawley.
When were you,
1989.
please describe your work history following admission to the bar?
I served as an assistant district attorney for approximately 12 years in Plymouth County. In 2001, I was appointed as a justice of the district court, where I currently serve.
As an assistant district attorney, do you ever recall redacting an arrest report to remove the statements of an arrestee?
I don't recall, but I want to be careful to provide any certainty to that.
Sure,
It's quite a
to the
bit of
best of your
time ago.
recollection.
To the best of my recollection, I don't recall that.
Could you describe your assignments since your appointment to the bench?
I was appointed, as I said, in 2001. I sat at a variety of courts in Plymouth, Norfolk, and Bristol County. I was appointed as the first justice of the Brockman District Court. I was also appointed as the regional administrative justice down at Region 2. And then in 2013, I was appointed as the chief justice of the district court. And in 2018, I was reappointed as the chief justice, which I currently serve as.
Where is District 2?
Region 2 is comprised of largely Norfolk County, parts of Plymouth County, and parts of Bristol County.
Could you describe your duties as chief justice of the district court?
My duties are outlined in by statute in, I think it's chapter 211B, section 10. There's numerous duties, but essentially I oversee the administration and management of 62 district courts and the personnel in those courts around the Commonwealth.
What are your duties as it relates, or what are your duties as they relate to the transfer of cases?
One of the enumerated statutory duties is the ability to transfer cases.
Now I want to turn your attention to the arrest of the young woman.
Are you having a senior moment?
No, not at all, but we, the petitioner, have taken great care not to name the individual who's the subject of the arrest and the subject of this event, so. The young woman who is the daughter of a judge.
Sure.
All right, so I'd like to, I would like for you to testify as to your communications with Worcester County District Attorney Joseph Early, all right?
Certainly.
And we're talking about your communications with him between October 17th, 2017 and October 20th, 2017, okay?
Yes.
Can you walk us through your first discussion? When was that?
So the defendant was arrested, I believe, on a Monday evening. If that's the 17th, it was a Monday night. If that's the 17th.
Okay. Why don't we try it this way,
Can
because
we stipulate, Judge, that it was the 16th
I'm
That-
sorry.
of October?
you
Okay,
stipulate that she
16th,
was
okay.
arrested on the 16th of
Yes.
October? Okay, great.
7:35 PM.
Thank you, counsel.
Thank you.
All right.
So I believe that's a Monday night. The first conversation I would have had with the district attorney was on late Tuesday afternoon, the following day.
And who called who?
I called the district attorney. I had previously had communication from the deputy court administrator in my office, as well as the regional administrative justice in Worcester, informing me of the situation. I called District Attorney Early. I notified him that we had this case, that it was likely to be a transfer case. I told him about the charges. I essentially told him the information that had been provided to me verbally by the regional administrative justice and the deputy court administrator. The charges, the facts, and the likelihood of a transfer. And at that point, I indicated I was unsure where the transfer would occur. I needed to outline and find a judge to accept it who did not know the judge, and asked him if he had any objection to the transfer, and he did not have any objection to it.
At the time that you spoke with District Attorney Early, had you decided that you were going to transfer the case out of Worcester County?
Yes.
And why were you contacting District Attorney Early?
Whenever I transfer a case out of a county, I always contact either the district attorney or the first assistant district attorney to notify them, because obviously they are the prosecutors of the case. If I was going to keep the case in the county, I wouldn't notify them. But the fact that I was moving it out of the county, in virtually every instance, I notify either the DA or the first assistant. In Worcester, I did not know the first assistant, so I contacted the DA, whom I did know.
And again, you're notifying the district attorney that you're transferring the case out of the county, but why are you checking in with him?
I wasn't checking in with him, I was notifying him. So the DA has the sole and exclusive authority to prosecute a case. And if it's the judge, I issue a transfer order that's gonna take that case out of the county. I feel it's my responsibility to notify that party.
Do you, District Attorney Early, retaining jurisdiction of a case you transferred out of Worcester County?
Objection.
That's-
Retaining jurisdiction, I have a problem with that.
Okay, no, that's overruled, I think. You need her to rephrase the question?
When you say retaining jurisdiction, do you mean following a case out of the county? Correct. Again, I don't recall that. I can't say with complete certainty unless I examine all the records, but I don't remember that. You're correct.
Thank you. May the witness be shown petitioner's disputed exhibit 16, which based on the rulings of the commissioner on the motions in eliminate should be admitted to the record. So I guess it would be marked as exhibit 15. Is that the number we're on? Thank you. And it is an email dated October 18th, 2017 from Sarah Adamson strike that, from Ellen Shapiro to Sarah Adamson, and Judge Dolly is copied on that email.
Thank you.
If you could hand it to the court reporter. Yeah. Judge Dolly, could you take a moment to review that, and then I'll ask you.
I am familiar with it.
Oh, you are?
Yes.
Okay, great. Could you identify that document for the record?
So for the record, what's now marked as Exhibit 15 is an email from Ellen Shapiro, our Deputy Court Administrator, to Sarah Adamson, who's my assistant. She drafts the paperwork for transfer orders. And this is an email from Ellen Shapiro to her saying, can you please draft paperwork for the special assignment of Judge James Sullivan to the case of the individual and transfer the case from Worcester District Court to the Framingham District Court. Next date is on for October 30th. Thanks. And this email appears to be dated Wednesday, October 18th, 2017, 7:36 a.m.
All right, and so that's 2 days after Ms. Bebo was, the judge's daughter was arrested, correct?
That's correct.
Okay. And where it says the next action, the next date is on for October 30th. What does that mean?
I have no idea. I assume that one of them must have.
Objection. I have no idea. That's the end of the answer.
I agree. Okay.
You have, you're copied on this email, correct?
Yes, I am.
When you read the email, what did you take that to mean?
I didn't even notice it. Frankly.
When you spoke with District Attorney Early the first time, what was the procedural posture of the case?
The defendant had been arrested the day before. What I believe to be the posture or what it was.
We'll start with what you believe to
I
be the
believe she
posture.
had been arraigned and the case was continued. I believe she had been arraigned that day. I was not aware she did not appear. In actuality, looking at the court records, it appears her absence was excused from the arraignment. I can't tell if the arraignment occurred without her from the docket sheet, but in any event, I think the case was continued to another date.
Thank you. Were you aware that the arrest report was impounded?
Yes,
Were you aware of the explicitly sexual statements in the arrest report?
I was aware of one statement in which the individual, I was told the individual had allegedly indicated she had prostituted herself in order to secure the heroin that she had been using.
And how were you made aware of that?
I was told that both by Deputy Court Administrator Ellen Shapiro as well as Judge Despotopoulos. They both recited the facts of the case to me, and that was included in each of the recitations to me.
Once you learned the facts of the case, what was your overall impression of the case?
Objection.
I'll allow it, if you can answer it.
In what sense, if I can ask you?
Disposition.
When I heard the facts, my sense was this was a very strong case, and you come to review the cases and you get a sense of what is likely to be a trial versus what is not likely to be a trial. And based on what they told me, I did not anticipate this was going to be a trial, given the strength of what was apparently the evidence.
Did you have any discussions with, and we're still talking about the first conversation with District Attorney Early, did you have any discussions with him regarding the statements attributed to daughter?
Not other than I told them what I had been told what the facts were, and that, that there was a crash. It was, my understanding, a high breathalyzer. It was, I think I was told there appeared to be heroin use while the vehicle was operated, if I'm correct. And that there was a statement where she mentioned her father, and there was a statement about the prostitution.
Did you have any concerns about those statements being in the arrest report?
No, because what do you mean by concerns, if I can ask you?
Well, yeah, did you have any concerns about it?
Well, can we narrow down the statements that she's referencing? Are we talking about the ones in question that were ultimately removed from it? I mean,
Right, no,
there's
that's
different
true.
statements there, so.
Yeah, so what statements are you referring to?
If I may, he just listed the statements. He listed the statements in terms of what he was informed was in the arrest report, and he listed 3 statements, and those are the statements that I'm referring to. Did you have any concerns about those statements being in the arrest report?
Because statements are contained in reports all the time. So, no.
When you spoke with District Attorney Burley the first time, did he make reference to the Massachusetts Rules of Professional Conduct with regards to the statements in the arrest report?
No.
Did he make any reference to his special duties as a prosecutor with regards to the statements in the arrest report?
No.
What is the distinction between an arrest report and a probable cause statement / narrative?
So Rule 3 requires the submission of a probable cause statement to support the issuance of a criminal complaint. And it's required to be supported by a statement of facts that constitute probable cause. Some police departments submit the entire police report. Other police departments submit a so-called statement of facts, which usually is a shorter narrative of the police report. And that would be the distinction.
But, and so if I understand your testimony, the arrest report or the facts in the arrest report can be also the probable cause
Objection.
statement / narrative.
Objection.
With your objection?
He stated his view, and whether Ms. Pruitt understands it is irrelevant.
Okay.
And the question is leading as a consequence.
It is legal.
I apologize. Can you repeat the question?
Madam Court Reporter, if you don't mind.
Question, okay. Also in the probable cause statement / narrative.
Yes,
Depending on the police, depending on the police department.
yes.
In your experience as a prosecutor and as a judge, what kinds of information are contained in an arrest report?
That support probable cause to support the elements of the offenses that the person is being charged with.
What about the statements of the arrestee? What about the statements of the arrestee?
In this case,
Period.
I'm
So
sorry,
I
I don't understand.
am asking you that in your experience as a prosecutor and a judge, what kind of information is contained in an arrest report?
I'll object to that question. It's compound, and with the witnesses having difficulty understanding it, I think we should break it down.
Okay, well, if the witness is very articulate, if he has a problem, I'm sure.
I don't understand the question.
Okay, that's fair
No,
enough.
I'll ask a different question. Why don't we go to your second conversation with Attorney Early? When did that conversation occur?
So it was either a day or two after that first conversation, he called me. He called me about the transfer of the case. He asked me if I had decided that yet. I told him I was still trying to find a judge. I knew who the judge was. I was having difficulty finding the judge. It turned out he was in, I believe, Utah. But he asked me because he made a suggestion to me. He suggested that I consider transferring the case to Essex County. He talked about a facility for females in Essex County. It was a detox facility. He said he had recently visited the facility. He thought highly of it. It was a 28-day detox facility. It had services to treat persons suffering from substance use disorder. And it had, he talked at length about the issue that it provided drug testing, but also medically assisted treatment. And I distinctly remember him talking to me about the importance of medically assisted treatment in the recovery process for people who suffer from addiction. And he also talked about when people complete the 28 days, he believed the program had the ability to place the individual in either outpatient or inpatient treatment as follow-up. And he made a point to tell me that Worcester County did not have that. He did not think it was fair that an individual could access that being in another county, and he asked me to consider that.
Was this the first time he contacted you about transferring a case to Essex County for the reasons you just described?
Yes.
Now, did you want to send it to Essex County?
I had pretty much made my mind up already that I was going to send it to Middlesex, Framingham. There were a couple of issues that concerned me about sending it to Essex. One was the distance involved. When we transfer cases, we attempt to keep the case in a contiguous county because otherwise it poses real inconvenience for the witnesses and the police to travel. And obviously from Worcester to Middleton, I think is in the Lawrence District Court jurisdiction. That would be quite a distance. The second one was more of a practical reason as to why I didn't think I could do it. And that is, I knew that the Essex facility is for individuals who are in custody. I had the impression that the defendant in this case was arraigned and released. And I couldn't understand in my mind how you could send the case to Essex and then take her into custody and put her into a facility. So I just didn't think that was going to work. It certainly it's a by everything I've learned about it, it's a tremendous facility and resource, but it just didn't seem to me it was going to work in this case.
And again, this is the only time that District Attorney Early suggested you send a case to Essex County for the detox, right?
That's correct.
In your second communication with District Attorney Early, did he make any reference to the Massachusetts Rules of Professional Conduct with regards to the statements attributable to the judge's daughter?
No.
Did he make any reference to his special duties as a prosecutor with regards to the statements attributable to? On to your third communication with District Attorney Early. When did it occur?
It occurred on the Friday at the end of that week. I was in the Stoughton District Court. I was participating in a what is referred to as a First Justice Listening Day. My duties require me to pick a First Justice, and as part of that, I go to the court. We set up meetings with court staff, members of the bar, police, prosecutors, defense lawyers, and members of the bar for the twofold purpose. One is to select the new First Justice and get feedback, but also to hear about the operation of the court and what improvements can be made. It's a process that's been in place a long time. It's an extremely voluminous, busy day. There's just constant from beginning to end. Every 15 minutes, they bring people in and you sit and talk to them. In the middle of that day, I received 3 phone calls. The first was from District Attorney Early. The second was from Judge Despotopoulos. And the third was from District Attorney Early.
Let's talk about the first call from District Attorney Early on October 20th, 2017.
So the first call was a very brief conversation. He said he had a motion to redact on the Bebo case, and he wanted to know who would hear it. I told him that a motion like that has to be filed with the clerk and heard by a judge. It was a very brief conversation.
And you recall him using the,
That was the impression I had. That was the impression.
did DA Early mention that he had a revised arrest report from the state police?
No.
In this first conversation with District Attorney, let me take a step back. Did District Attorney Early indicate what he intended to quote redact? Did District Attorney Early reference the Massachusetts Rules of Professional Conduct with regards to the statements attributable to the judge's daughter in this first conversation on October 20th?
No.
Did he make reference to his special duties as a prosecutor with regards to the statements attributable to the judge's daughter on October 20th?
No.
In your experience, how often do prosecutors proactively remove the statements of an arrestee from an arrest report?
Objection.
That's all.
I'm sorry.
That's all. You can answer the question.
Not often.
You said before your second conversation with District Attorney Early on October 20th, you had a conversation with Judge Despotopoulos.
That's correct.
Could you tell the commission about that call?
So Judge Despotopoulos called me. He said that the DA's office had a motion to redact, that they had gone to the clerk with it, and that the clerk referred them to Judge Despotopoulos, and he wanted to run by me what he was thinking of doing, of hearing the matter. I told him that the matter had to be heard in a courtroom on the record, that it had to be, if there was a redaction, that the original report had to stay with the file, had to be sealed essentially with the file. That's the process. He agreed with me. He said to me, we're on the same page. And my impression was he was then going to go hear the matter.
When you spoke with Judge Despotopoulos, did you indicate that you'd already spoken with District Attorney Early?
I believe I had.
And that you told him that the motion needed to be filed with the clerk's office and heard by a judge?
I don't think I get into it. Again, it was a very brief conversation. I know he was talking and I interrupted him and said, I interrupted him and got right to the point because I frankly didn't have a lot of time to discuss this.
Why don't you tell the commission about your second discussion with District Attorney Early on October 20th?
So later on, at some point, the district attorney called me and said the motion was heard and it was allowed, and he asked me if he should send me a copy of the motion, the redacted report rather. And I said, was this heard in court? He said, yes. And I said, that's not necessary. I said, when I get back to Boston next week, I'll act on the transfer. And again, it was a fairly brief conversation. But I told him I didn't need him to send me the report. I think I actually said, was a clerk there, and the clerk handled it, and he confirmed yes.
At some point, did you learn that the state police had issued a revised arrest report?
I did. I believe I learned of it when it was published, when it became a news piece.
And so transferred the case to Middlesex County, is that right?
Yes, the following Monday, I was able to speak to Judge Sullivan. He agreed to hear it. He indicated he did not know the judge, and he told me he'd hear it. I then signed the order, and we transmitted the transfer order that Monday.
Did you have and so now we're past the transfer of the case. Did you have a subsequent discussion with District Attorney Early about Massachusetts Rule of Criminal Procedure 3.
Yes,
And when did this discussion occur?
it was well after, probably a month or two after. I couldn't tell you exactly when, but it was a good while after the transfer of the case.
Who called who?
Actually, he called me because he said he wanted to talk to me about specifically probable cause statements, information and police reports.
And why don't you tell the commission about that discussion?
He said it sounded like he was considering a proposal on this, and he talked to me. It was a lengthy conversation about Rule 3, what's contained in police reports, how that information is transmitted to a clerk. There was a discussion about electronic application of criminal complaints that I was able to tell him about. It was in this conversation when he was very clear to me, he felt that the material in the police report in this case was not appropriate. He told me that he felt strongly that it was a serious detriment to the recovery of people in recovery. And so we had this conversation. He believed that this type of information should not be in a police report and available for public consumption, that people had to live with this forever, and it really was a problem in terms of long-term recovery. I explained to him, we discussed Rule 3, but I explained to him electronic application of criminal complaint, and it was something I knew a lot about because at that moment we were just implementing it in the district court. And in a nutshell, what it is we've changed from a paper system to a transmission of police reports by police departments electronically to the clerk. And I told them that the way the system is set up, it only allows for one report to be submitted per case because the system interconnects with the CJIS and it picks up the criminal record and allows that information to flow, and it ends up in the production of a criminal record. And then if you submitted more than one document, it would create a second entry. And the vendor who was doing this had explained that to us, that you can only submit one report. If you're trying to submit a supplemental report, it will create a second entry, if you will. So we talked about that at length, and I think I told him his suggestion was meritorious in many ways, but it's just something the trial court could not accomplish. It's not possible.
And in this discussion, 1 to 2 months after you transferred the case to Middlesex County, did District Attorney Early reference the Massachusetts Rules of Professional Conduct?
He did in that conversation.
Reference the special duties of the prosecutor in
Yes,
that
he did.
conversation?
He did. He felt it was his obligation on those fronts.
In an interview with the Attorney General, you said that if you had to do it over again, you would have asked more questions about the redaction. Do you recall that?
Yes, I do.
What questions would you have asked?
Well, I think I was referencing if I had to do it over again on that Friday, when he questioned me about where the who should handle it, and Judge Despotopoulos called me. I believe I said I would have slowed things down. I would have tried to get more information. And I most likely would have just told him, continue the matter. Let's send it to Middlesex County and you can handle it in Middlesex County. I think that was the point I was making, is sometimes you make these decisions, they're very quick. You don't have all the information necessarily you'd like, but you do the best you can with the information provided to you.
And as I understood your earlier testimony, you'd already decided to send it to Middlesex County when you had your first conversation with District Attorney Early.
That's correct.
All right. Now, given that the arrest report was impounded and you were sending the case to Middlesex County, what was there for District Attorney Early to do?
Well, I want to be clear, the transfer order itself governs where the case goes. It in no way directs the district attorney, because as I said, they are the sole and exclusive prosecution authority. I can't control that. And that's I guess the point I would make to your question.
Well, if you were slowing things down,
Yeah.
if you had it to do over again and you were slowing things down, what was there for District Attorney Early to do if the case was impounded and you were sending it to another county, whatever county you were sending it to?
Objection, the first part of the question doesn't relate to the second one.
I just want to break it up and just ask the questions sequentially.
You'd already decided to send the case to Middlesex County, correct?
Correct.
And the case was impounded.
Correct.
And if you had it to do over again, you would have slowed things down and told everyone just let the transfer take place, correct?
Objection, the question presupposes that Mr. Early has no responsibility left after the case goes to Middlesex, and the witness has already said that's incorrect.
Yeah, I think that's where she's going, I would think, so, go ahead.
Well, actually, if I could go back to your earlier testimony, you do not recall this where you transferred a case to another county and Mr. Early has retained jurisdiction, correct?
Objection.
That was your, that was,
Jurisdiction.
excuse me.
Yeah, go
I'm
ahead, just,
sorry.
go ahead, just
I
ask the
believe
question.
that was that question was asked
That
and
is what I
answered
said.
earlier. Okay,
Okay.
all right.
So if I could, to your question, the one thing, it's, from my perspective, make a lot of decisions every day. But one thing I would point out to you, and I don't want to minimize this case, but this was a non-dispositive motion. This to me was a non-substantive motion. And I don't want to minimize the importance of it, but at the time it was presented, it did not have great significance to me in terms of saying, go ahead and hear that case. It only became significant later when there was public attention and public questions about how it was handled. But at the time those conversations took place in a very hectic atmosphere, it didn't stand out as significant to me. So perhaps that would help you understand why I didn't stop everything and say, let's re-examine this.
Understood. May I have a moment?
Sure.
Yeah, why don't you give us, yeah, thank you, thank you. Thank you.
I have no further questions at this time. Thank you.
Thank you.
Okay, thank you very much. Ms. Burke, what do you have to say?
Good afternoon, Judge Dolly.
Good afternoon.
I'm Attorney Tim Burke. I represent Major Anderson. We talked about transferring the case from Worcester County to Middlesex County. Was your goal to try to have an independent judge review the case
Yes,
for the substantive resolution of the case if it's going to be a plea?
yes.
And was that in part due because Judge Bebo had worked in Worcester County as a district attorney prior to becoming a judge?
I wasn't focused so much on that. I knew he had sat in several of the courts in Worcester County.
But in any event, you made the decision. And again, we're talking about the distinction between the executive branch, which is the prosecution, correct?
Correct.
And then we're talking about the judiciary branch.
Right.
You have the authority to transfer the case to another jurisdiction, right?
Yes,
And Mr. Early has the authority to appoint a special prosecutor from outside his office. Isn't that true?
yes.
And was there anything in terms of those redactions? Have you since seen the 3 sentences that were removed from that police report?
I did. The day that I signed the transfer order, I actually saw the original report. the court actually had sent it to me.
Would you agree with me that what is important in a police report is information, whether it's statements that are made by the individual who's being arrested or observations? It's those statements that go to support probable cause, not those that are just independently salacious statements that have no particular point to establishing probable cause.
The probable cause statements have to support each and every element of the charges in the complaint.
Would you agree with me, sir, that the statements that were removed by that act of redaction, those statements did not contribute to probable cause in this case of an OUI?
Some of them would not support the elements of some of those charges. You're correct.
Thank you. Now, when this happened, again, this is not the only case that you're made aware of on a single day, is it?
That's correct.
In terms of the cases that you were asked whether or not this has ever happened before. If there were a situation that was brought to your attention and it wasn't a judge's daughter in a similar circumstance, would you take a different course of action?
No.
Would you do anything different than you did here today or it did in that case?
No, other than to counsel's point, I look back and say, I probably should have slowed things down and looked at it. But again, I'm acting on what I know at the time.
Well, Judge Dilley, I'm not being critical. I'm just saying everything looks better in hindsight and a lot clearer.
No question.
So, but the chief judge in Worcester who heard the redaction motion, so is it what you're saying that it would have been even better to have that removed into another jurisdiction?
No, and I will say, I want to be very clear, I have great respect for that judge, his experience, his judgment.
I agree.
He's a terrific judge.
So in terms of the redaction, when it took place, did you know my client's role in that?
Just from what I've read in the, frankly, in the newspaper.
If I can tell you, she was the major in charge of the troop who was tasked with an order to revise those portions of that report that did not contribute to probable cause and which were blatantly salacious information.
Yep.
Okay, that was her order that she was giving. And once that occurred, as I understand it, you wanted to make sure that any change or any redactions were done in open court.
That's correct.
Okay, and you tell the commission it's obvious, but tell us why you wanted it to be done in open court.
I think any impoundment, any redaction, any motion to strike, those are all remedies that people use all the time to strike information that they don't believe should be publicly accessible. And the reason we have these rules is there's a procedure you can employ to go into court, but it's got to be done in court on the record. There's got to be an established docket that reflects what happened. And those are the purpose of those rules.
Okay, so we have an impoundment, the first hearing when this is brought before the court for her arraignment. And again, you didn't know whether she was arraigned or not, right?
Yep, right.
She has an attorney. Did you understand that she had a defense attorney appointed for her?
I did sense, yes.
Okay. And did you know that defense attorney, not Joe Early or Jeff Travers or my client or anyone else, that defense attorney filed a handwritten motion to impound that document, the police report that she got that day? You understand that?
Yes, I've since seen that document.
Okay. And the motion to impound, based on your experience as a judge for how many years?
21.
And as a prosecutor for how many years?
12.
Anything wrong or illegal about the motion to impound that document?
No.
And so it goes from being impounded. And actually, would you agree with me that if the defense attorney hadn't done something like that, she could be subject to criticism for failing to file that motion?
I suppose somebody could raise the issue of why the lawyer didn't zealously represent the client and file a motion.
All right. So that goes in, this is before there's a redaction. That goes in front of another judge, correct? And the judge, who's that judge?
The judge that originally acted on the impoundment,
Yes,
I think it was Judge David Locke.
okay. And is that done in open court?
Yes,
Is there a transcript of that?
I haven't seen one. I don't
All right,
know.
but, okay, just so the public is aware, is there a transcript made of court proceedings as they're happening, including
Yes,
this
there's a
impoundment?
recording that would be going on that would record all the events in the courtroom.
Open to the public. Nothing to hide here. Anybody can have access to that, the hearing itself, the transcript, can't they?
Yes, in some instances, if you're seeking to redact and you're raising issues, you may request an in-camera hearing, particularly if it involves safety of witnesses, ongoing investigation, you believe harm would come to somebody. I've seen situations where lawyers say, can I be heard in camera so that I don't put this out publicly as to why I'm asking you to do this.
Okay, that's a little more information than we needed here. I'm talking about this case. So in this case, that's an open to the public hearing in which there's a tape recording of what goes on, right?
Yes,
And the judge has discretion to say, no, I'm not gonna do that, or yes, they are gonna do it.
that's correct,
And in this instance, Judge Locke issued an impoundment order, right?
correct.
Okay, and then from there, there's the various conversations that you talked about that you had with the District Attorney Joe Early, right?
Yes.
Can I just ask you, do you think it's commendable that somebody in his position would actually want to help somebody who is drug addicted?
Personally, yes, I do.
Thank you.
No, but we're in a system now where our court is always referred to as a problem-solving court. There's good reason for that, because a majority of the people we see have substance use or mental health issues, and the court system has shifted significantly to address those issues. So I would say that is commendable.
Thank you. And so after those conversations, and you have your discussion, there then is a second hearing, correct?
On the impoundment,
Yeah, no, I'm sorry, after the impoundment, you have conversations with Mr. Early, there's a discussion, there's a decision made to redact the
yes.
the offensive, for lack of a better
So,
word.
so yes, that Friday there was a second hearing.
Okay, and is that in front of a different judge other than Judge Locke?
Yes, it was heard by Judge David Despotopoulos, who's the
Okay.
first justice in regional administrative justice.
And to your credit, when you received the call from, I don't want to mispronounce Judge
Despotopoulos,
Despotopoulos' name, but when you get the phone call, do you want to ensure that this is done out in the public?
yes,
Did you tell him, make sure this is on the record, that there's a formality to it?
yes, and he agreed with me.
And was that done?
My understanding was yes.
Bear with me a second, please.
Would you like a drink of water?
No,
Because we have, if you want, just take that.
thank you.
You were asked about slowing things down. That's not the manner in which you said it, was it? When you first testified.
I think I might have.
Okay, well,
I think that's the term I did use.
in terms of what was done,
And I'm referring to myself now
okay,
in terms of that decision.
right, when you did make the decision to have this done, well, that's consistent with what you would do in any case, isn't it, in terms of the motion to redact?
I think if a party has a right to file it, the court has to be available to hear it. Now, this was a little bit more complicated because of the decision to transfer, but I think the court is required to provide a forum for someone to be heard.
Did you do anything other than that in terms of your experience and your responsibilities as the Chief Justice of the District Court?
No.
Nothing else. Thank you, sir.
Thank you. Ms. Kiley?
Thank you.
Good afternoon, sir.
I'm Kylie, as you know. Along with Ms. Vieira. You were a prosecutor in the 80s,
Really the 90s.
and when you were a prosecutor, you were trained in things like the professional rules that apply to you as a prosecutor, were you not?
Yes, I was.
And as a you're aware that you were a minister of justice, correct?
That's correct.
And as a minister, you had obligations, correct?
Correct.
And those duties included trying to protect individuals from pretrial publicity, did they not?
It's correct.
And as an assistant district attorney years, you were also aware that the district attorneys made decisions with respect to what the evidence was that was going to be put before the court, correct?
Yes.
And you talked with Ms. Pruitt about pleas, correct? If you don't recall, I'll withdraw the question.
About people pleading guilty?
Yes.
I'm not sure if I did or not.
Okay, so I withdraw the question. So, one of the things that has changed over the course of time since you and I were prosecutors is the plea procedure, correct?
Yes, that's correct.
And when you were prosecutor and there was a question on a plea that a judge might ask, the prosecutor would make decisions about what to present by way of the facts in the case,
Yeah,
correct?
absolutely.
That was the DA's, that was the assistant, that was the prosecutor's call.
Yes.
And with respect to the evidence that goes before the court, the actual evidence, that is always the prosecutor's call, is it not?
That's correct. That's a pretty basic separation of powers issues. Court should not be involved in telling a prosecutor what to present and not present.
And the transfer of a case by a judge within the judicial branch has no effect, does it, on who the prosecutor should be?
That's correct.
So there are district attorneys who, in your experience as the Chief Justice, always want their prosecutors to follow the case into the other jurisdiction where it is going to be tried.
It does happen.
It is a discretionary call on the part of the district attorney, not you as Chief Justice.
That's correct.
The case that we have been talking about was in the district until your order of transfer became effective, correct?
Yes.
And until some other prosecutor took the matter on, Joe Early and his office were the prosecutors in the case, were they not?
That's correct.
And they had duties, did they not, with respect to pretrial publicity?
Yes, I do.
That doesn't change with the transfer. Nothing changes in that regard.
I don't believe so.
When you first looked at the comments that have been discussed here today, did you form a view whether statements could result in prejudicial pretrial publicity?
I'm not sure I viewed it in terms of pretrial publicity. In that regard, I was particularly sensitive when I read it to the statement about the statement that jumped out at me was the prostitution statement.
And that was a statement that could cast public opprobrium on the individual if made public.
No question.
When you had your initial discussion, expressed the view, did you not, that the facts here were horrendous
That's correct.
and that they were a parent's,
That's correct.
and that those statements were problematic?
I was looking at it more, I'm not sure problematic is the right word, but I was looking at it more just with, I felt badly for obviously the individual and her family that they were dealing with this terrible issue.
And in your statement to the Attorney General's office that you were asked about, you indicated that you were talking about how difficult this is on families and parents dealing with children who are engaged in this type of addiction.
That's correct.
Correct?
Correct.
And that was a statement that applied to any parent and any child, correct?
It's unfortunately, it's what we see every day.
The approach to that changed dramatically. Years that you have been a lawyer and a judge, correct?
Correct.
There is a different view that prevails in the law enforcement community, writ to include and police agencies, correct?
Yes.
And with respect to your authorities, therein, I think you said, and I think it's correct, Chapter 211B, Section 10. Are you aware of the powers of the state police colonel under Chapter 22C?
I can't say I am.
Are you familiar with host statute?
Yes, I've read about it.
And it reflects a new approach that was not in existence 10 years ago, correct?
Correct.
Training standards for judges changed over the years?
Significantly.
And are you aware of what training changes are being made with respect to addiction, with respect to police officers?
In a limited way. I mean, I
We won't,
read about it, but I don't have
yeah,
any in-depth
we won't
knowledge.
dive deep. It was your impression in the first discussion with District Attorney Early that you were providing information to him, correct?
That's correct.
And again, you were the initiator of that call.
I called him, that's correct.
And in terms of the horrendous facts and the awful effect on families, is that something you brought up? That is something you brought up, isn't it?
The conversation was such that I told him what the charges were, the facts. I told him I wanted to transfer it. He didn't object it. And then we discussed how difficult a situation this was for the judge. And then generally how difficult it is for families who have to deal with this. That was the conversation.
Focus was on families and these facts, correct? As opposed to Judge Bebo, the judge whose daughter.
Correct.
The next conversation with District Mason in time.
I don't know the exact date, but I put it at least a day or two after the original conversation.
And he initiated that call to you,
That's correct.
and that is the call that dealt with the program in Essex County.
That's correct.
And when you talked about a facility and the fact that she was not in custody.
Yes.
Your understanding of the facility was that it was a place where people who were in detention could be placed.
Yes.
And so you didn't grasp that it might have some relevance to the situation with respect to the judge's daughter, correct?
That's correct.
And I think you testified that you didn't see the case as one that was going to go to trial.
That's correct. My initial thought was these facts are very strong.
When you looked at the facts, and there was as you called it, an indication of prostitution to obtain drugs, did the thought go through your mind that there might be a human trafficking case to be had?
I didn't really think of that.
What do you think now?
Objection.
Yeah, no, he can have it, if you can answer that.
It's a topic that comes up often more now in terms of how we treat people in the system who are victims of prostitution and human trafficking. I mean, there's many prosecutors who take the view that they're victims and they won't prosecute them, or that they will get them assistance. It's definitely viewed much differently than it was in past years.
And if a human trafficking case were brought, it would be against the person, not the person who is performing the sexual acts, but against somebody who is using them or forcing them to do that, correct?
Yes, the person who's performing the acts is viewed as the victim.
And victims have rights, correct?
Yes.
The statement that, strike that. When you were in Plymouth County trying cases against Willie Davis, you were dealing with major crimes, correct?
Yes, homicide cases.
And you started off doing what everybody did in the district court.
Yes.
And in terms of the Superior Court matters that were serious cases, the charging document is an indictment, correct?
Correct.
And in the district courts, it is a complaint, correct?
Correct.
And the supporting information in the Superior Court is basically material that is entered in the for probable cause, is entered before the,
Grand jury minutes, yes.
and it's confidential vis-a-vis the public as a general proposition, isn't it?
That is correct.
And in the district court, now, because of the technological wonders of the century, it's not one document that goes in the electronic system.
Yes, limited under the EACC to one document.
So when we talked about, when you talked with District Attorney Early, it was the electronic filing, and I'm not going to get the letters. You were contemplating what has become Standing Order 219, correct?
We did issue a standing order on the application of the EACC, if that's what you're referring to. Is it
Yeah,
219?
yeah, it's 219, electronic application for criminal
That's
complaint, correct? And I'm looking at a document that suggests it was adopted on December 18th of 2018 and took effect on January 1 of the following year.
Yes.
You thought that the points that District Attorney was making with respect to what belonged in had merit, but it couldn't be done, correct?
They were fair questions to raise, but I told them it was simply not possible given the system we have.
Or the system that was then going in,
Yes.
whichever it was. So I want to quote a particular passage in the procedure section. If the clerk determines that an application submitted by EACC is incomplete or is otherwise unacceptable for filing, he or she shall alert the complaining officer or agency as soon as practicable. That is something that was put into the rule that you were adopting as a standing order, correct?
That is correct.
And that would enable a clerk then to make some decisions with respect to what the document is that would go in,
Yes,
correct? The clerk shall have the discretion to permit the applicant to correct the already filed, incomplete, or otherwise, I'm reading that correctly, erroneous application, or to submit a corrected application by EACC, correct?
Correct.
And so the opportunity under the system to file something that is corrected exists, and that would be the one document, to contest the good application.
Right.
Now, you know, you knew time of your interviews that policies with respect to what would go into a application for a complaint vary from police department to police department.
yes. We learned that as we implemented EACC, that different police departments did it different ways.
And you testified, I believe, under oath, that you were aware that in Worcester, but I think with reference to the Worcester Police Department, they filed short statements or gists with respect to applications for complaints, correct?
I'm gonna object. What statement under oath are you referring to?
I asked the question and I got an answer.
But what statement under oath are you referring to is my question.
I didn't refer to one.
Why don't you just repeat the question?
I have a question.
You're referring to the statement of facts?
I think I am, yes.
That's, can I answer the question? So if you're referring to a statement of facts, that is correct. So some police departments submit the entire police report, other police departments, and I believe Worcester, in the city of Worcester is one of them, they submit a shorter narrative.
That is a policy judgment that is left to individual departments.
They are entitled to make that decision. Whatever they want to present is whatever they present.
And are you aware of what the district attorney's policy in the Middle District was?
No.
We're in, strike that. I want to talk about impoundment. Again, when impoundment was, there were no uniform rules on impoundment. They came later in the game,
Right.
correct?
Correct.
There are uniform rules of impoundment.
Rather, trial court rules.
And those uniform rules provide, do they not, or require a time duration?
I believe it's a 10-day time period.
And in 2017, a 10-day time period would have been in the rule.
It is the
If
rule
I-
now.
if I-
I assume it was in 2017.
If I refer to the 2000s, if I may. Rule 8, the uniform rules on impoundment procedure. Rule 3B. Last sentence, an ex parte order of impoundment shall expire 10 days from the date of issuance unless otherwise ordered by the court for a good cause shown. That's consistent with your memory, correct?
That's correct.
And Rule 4 of the uniform rules, as you know, provides for service of orders of impoundment, correct?
Yes.
And Rule 4, are you aware that in this case, Judge Locke's order ran to the state police department and required them to be served?
I was not aware of that.
And a service on like that. Are you aware, sir, that the rule imposes an obligation on all persons, not to violate an impoundment order?
Yes,
And that would apply to not just the parties to the case, but an impoundment order under the rules is to be honored by everybody, correct?
that's correct.
Now, in the time, your case had not, this case had not been transferred of the Monday, correct?
It was transferred on Monday.
On the Monday, the 23rd. At that time that it was transferred, District Attorney Early was the prosecutor.
Correct.
He had special obligations, and special obligations included trying to prevent pretrial publicity, correct?
Right.
And would have had a finite life, correct? Strike that. If there was no date specified, it would expire automatically in 10 days.
I think if there's no specific date set by the judge, by operation of the rule, it expires after 10 days. That's how I read it.
So at the point that there was a discussion of redaction on the Friday before, so if I back up, I think I'm going to get to the 20th. At that point in time, the transfer had not changed his duties.
Right.
And there were statements that he thought should not be in the report, correct?
Clearly.
That should be redacted, correct?
Correct.
And he had the authority he had the authority to file a motion to redact, correct?
I believe that he, as the prosecutor, had the authority.
And that is, you believe that as the prosecutor, that's his authority as opposed to somebody else's.
Clearly not my authority, his authority as the prosecutor.
Thank you for the correction. And that is, you have captured what I was trying to draw. Thank you. The order would expire the impoundment order would expire as a matter of law. Correct?
Would have been 10 days from the Tuesday. So if she was arraigned Tuesday, if the order was done Tuesday, it'd be day 10 after that.
We'll consult the calendar and I'll make it later. In your professional judgment, the effort to redact was an appropriate exercise by the district attorney?
I don't want to judge appropriate, but I think it was an option that was contained within his authority. I don't want to characterize. I think that's somebody else to determine, but I think certainly he was in his legal authority to file it and be heard on it.
EACC
EACC.
was not in effect at the time, correct?
No, it was in effect in some places. The rule issued later, but for about a year and a half, we had started going around the state and implementing it in pilots all over the state to get the police departments on board. So the actual implementation occurred before the standing order issued.
So during that period of time before the standing order issued, were the standards on the complaint procedure published by your predecessor, Ms. Linda Conley,
Justice Conley, yes.
in effect?
Yes, they've been in effect, I think, since 2003 or 2004. They went back some period of time.
getting old, 2008 according to the paper.
Is it 8?
Uh, um, I want to direct attention to back of that one. Under the rules, there was an opportunity as well for a clerk to suggest to the complainant the material should not be in the police report, was there not?
Correct. Similar to the rules on impoundment, the rules that govern criminal complaint standards allow the clerk that discretion.
And in the end, the complainant is the complainant, correct? Never mind. I'm gonna refer you, when you look at the standard, it's 503 and 504.
I'm happy if you need it.
No, I'm fine.
All right.
And I think I'm done. I'm done.
Let me, before you sit down, as I said, certain fellow commissioners are listening and you know, they've had some questions. So one of the questions is, in slowing down, did the witness think he should defer the motion to redact to the transferred court? Like when you testify, if you can answer this, when you testified that you wanted to slow down things, you know, my colleague saying, one of the things that you considered, did he think he should defer the motion to redact to the transferred court?
It's possible. When I say slow it down, I look back in hindsight.
Sure.
But when I'm making that decision, I'm making it with what I know.
Sure.
When I say hindsight, I look back and say, you know, how could, if you look back in a perfect world with more information, would you have done something different? And it's possible it would have been, you know, let's hold on, let's transfer the case, and the motion can be heard in the other county.
So, you know, my fellow commissioner says, what would you have done differently? And looking back, and you said, you know, if you can answer that, you may not be able to answer that, obviously, but she wants to know, what would you have done differently?
That's a hard question. I think in
Yeah.
everything in life, and whether you're working in the court system or anything else, you always look back and say, you know, maybe I could have done something differently.
Okay.
And I think it's important in this case, you know, you look back and see, you know, you always strive for some excellence in our system. How can you improve things?
Sure.
One of the things I did in this case was I changed the procedure. One of the issues when I look back at this was I was not in my office for about 3 days. And I always personally signed the orders. I've now given the authority for signing authority to the people I work with so that this could be done immediately. Doesn't have to wait for me to appear in person to do that. I was always trained as a judge, don't ever let anybody sign your orders, you sign your own orders. And I had that mindset, well, I've come to realize, you know, administrative matters can be signed by other people. That change is something I would do differently.
Okay. This is another question that the fellow commissioner has. The judge said some of the statements in the police report would not support the elements of the crime. And then the commission wants to know which would not and then which would. So this commission is obviously interested in these certain statements. Judge said some of the statements would not support elements of the crime, which would not, and then which would. So I pass that along to you.
Does he?
I'm trying to think of the statement.
Does he need the report?
Yeah, that exactly. That's
Just
what
by
you know.
pointing out the ones that were removed to make it shorter. He has the 3 sentences that are removed.
And this is kind of putting him on the spot here, you know. So, thank you. So this is the report.
So one thing I'd like to make clear
Okay.
is the judge who made the decision to redact, I support his decision. He's an experienced judge, he's got excellent judgment, And I really am reluctant to impose my thoughts or second guess his decision. And I didn't mean it, if that's what it sounded like, I'm certainly not doing that. But I frankly don't want to comment on another judge's decision-making,
No,
which is what this would ask me to do, I think.
I don't think that's, you know, go ahead, what do you want to say, Mr. Bourgeois?
You read all of the orders to show cause. The last in time claim of wrongdoing by the petitioners ends with the discussion between Mr. Travers and the clerk. What happened afterwards, which was the redaction in front of Despotopoulos, I thought they stipulated there was no claim of wrongdoing by Travers or by Judge Despotopoulos in connection with that redaction.
Okay.
It's not alleged anywhere, it's never been alleged, it's not part of this case.
Okay, well, that's all I have.
You didn't have me sit down, so I'm gonna ask one more question if you allow it.
Well, thank you. Thank you, feel free.
I'm going to direct your attention to Rule 14, the Uniform Rules on Public Access to Court Records. I'm aware of that
Yes, sir.
trial court rule. There is an addendum to that rule, which is captioned Massachusetts Court System List of Authorities designating material as impounded, confidential, and not available for.
Agree with that.
And there are numerous things that are listed there,
Yes,
correct?
yes.
Some of them dealing with matters related to substance abuse, some related to matters related to activity, correct?
Yes, I think mental health is one of the enumerated ones as well.
Thank you.
Thank you, Mr. Kiley. Are you gonna go now, Mr. Risconi, or is it Mr.?
I only have a few questions, so.
Is it okay for him to go? Okay, yeah, what do you say, Mr. Risconi?
Good afternoon, Mr. Justice Valley. My name is Mike Risconi. We've met before. I've been in front of you once or twice. I'm not sure if you recall or not. It was some time ago. I represent retired Arnold Kuhn. I just have a couple of points to make. Now, in your practice as a judge in the district courts, probably more likely than anywhere else, you did plenty of OUI trials, I'm sure, correct? Correct. And that's both as a prosecutor and as a justice, correct?
Yes.
And this may answer some of the last question that was posed. So you're in agreement with Judge Despotopoulos' decision, which your understanding that those statements were redacted because the probative value was outweighed by the risk of undue substantial prejudice with respect to the case itself.
So I've never discussed that decision with him. But I can tell you, he's a very thoughtful, highly competent judge. I've never said to him, why did you do this? What were the factors you took into account?
Correct.
But I have great confidence in his judgment.
So let me ask this another way then, but that, in your opinion as a justice, that is a grounds for a defense counsel to move to have those statements in limine excluded because of the risk of substantial prejudice as opposed to the probative value.
That's correct.
And you referenced the facts as they were relayed to you, and have you had a chance to ever review the report?
I just read it once. The day I signed the transfer order, the clerk's office had sent the unredacted report, and that's when I read it.
And your impression as you sit here today, and I obviously don't expect you to remember all the details, but your impression was this is not going to be a trial because these facts are terrible.
I thought the facts as I understood them were significant, and this did not appear to me a case that you could try.
And do you recall there being an accident where the operator crashed into a pole?
I know there was a collision, yes.
And you referenced admission to heroin use, correct?
I believe so, yes.
Okay, and this is an OUI drugs case, an OUI alcohol case, correct?
Both, yes.
And you were aware that there was a relatively high blood alcohol content reading from the Alka-Test machine.
If I remember, it was over 0.20.
Correct. And in fact, that is so high that if someone were to either be found guilty or to plead, they'd be required to enter an accelerated rehab program, I believe it's the 24Q.
Yes, it would trigger the automatic imposition of 24Q, you're right.
And because it's such a high reading, correct?
Yes, anything, I believe, 2.20 above.
And I'm sure that you recall at least reading over the field sobriety assessments, and your recollection would be that they were not performed particularly well, fair to say?
I frankly don't remember.
Okay. But based on what you do remember, you would agree with me that a statement after booking that doesn't necessarily directly relate to the elements wouldn't move the needle for you as whether this could be a jury trial or it would be a plea, correct?
I'm not sure I understand the question.
The facts that we've already gone over, that to you is sufficient to say this isn't going to be a trial.
It appeared to be a very strong case.
Correct. And absent the statements that have been redacted and revised, you would agree that without those statements, it is still a strong case.
I agree with that.
And in administering, as presiding over a jury trial, this goes to pretrial publicity. There are certain questions you ask the jury pool, correct?
Yes,
One of those questions is, have you heard or read anything about this case?
correct.
And the reason that is because that could shape somebody's opinion before they hear the facts, correct?
Correct.
You'd agree that facts as they come out of the jury trial are not necessarily all the facts that are communicated through the media. Is that accurate?
So the facts that come out of a jury trial?
The facts as they're elicited throughout a jury trial are not necessarily all the facts that are presented by the media, correct?
I think that's true, yeah.
Again, because you don't want someone to have a opinion going into the trial in the first place, correct?
Correct.
So, and you'd agree with me that a case where, something is published in the Boston Globe, there's a substantial risk of pretrial publicity, and would be difficult or more difficult to seat a jury based on that, correct?
It certainly creates the potential for that.
Okay, thank you. Yeah, Ms. Bouchoir? Sure.
Good afternoon, Judge.
Good afternoon, sir.
My name is Roy Bouchoir, and I represent Jeff Travers, who is the first assistant for the Middle District. And Chief, have you ever met my client?
I don't think I've met him in person, but during the pandemic, there've been a lot of Zoom meetings, and I know I met him on the Zoom meetings with a bunch of other people.
It's fair to say, however, that you never communicated him at all in connection with the arrest that brings us here today. Is
That's
that right? Okay, I just have a couple of questions I wanted to ask you, some of which will go over some grounds you've already heard. Of the 60, how many district courts you supervise?
62.
Of the 62, where does the Worcester District Court rank in terms of volume of busyness?
It's the second busiest court in the Commonwealth. Springfield is the first.
And that's because Worcester and Springfield are centrally located and they get cases from large areas?
Yes,
And so would you agree with me that the judges in the morning sessions in the Worcester District Court are busy?
correct.
They've got a lot of volume, they've got a lot of cases to push through, and a lot of things have to happen on an expedited basis. Is that right?
That's correct.
And in a busy court like Worcester or Springfield, it's not uncommon because of the press of time in business for motions to be handwritten as opposed to typed, correct?
That's correct.
And it's also not uncommon for motions to be made verbally instead of handwritten out, correct?
That's correct.
And it's not uncommon for an experienced lawyer to ask a clerk for guidance on a question rather than, and see if a judge doesn't have to be bothered with the matter at all, correct?
I think it happens frequently.
In fact, isn't it true that the trial court rules in some cases specifically refer to the clerk being authorized to give guidance on issues?
That's correct.
I want to ask you a couple of questions about the uniform rules of impoundment procedure. I have a copy here, and it's unfortunate, I've only got one copy. If you feel you need to look at it, I'm going to be talking about, I think it's Rule 8 and Rule 9.
Sure.
Rule 8 talks about what the judge does, and Rule 9 talks about what the clerk is supposed to do.
I'm familiar with those.
Okay, good. Could the witness please be handed for a moment exhibits 5 and 6? If you could get those ready, I'll ask you some questions about the uniform rules, and I'm gonna ask you about a couple of exhibits here.
You want me to hand them over now?
Well, just let me get a couple of preliminary things. Do you agree with me that the uniform rules of impoundment specifically require in Rule 8 the judge to state an ending date for the impoundment? You want to look at the rule?
Without looking at the rule, I believe that to be the case. I
And
think
do you
there
agree
has
with
to be-
me that I think it's rule number 9 that specifically requires the clerk in the docket entry to put the expiration date?
That is correct.
And do you also agree with me that Rule 8 requires the judge to make specific findings prior to impoundment?
Yes, I believe that's true.
Okay. Now, I'm going to ask you, if you would, to look at these two documents. But the reason I asked you, just to be clear, nothing I'm asking you is critical of Judge Locke. You're talking about a judge in the morning of the busiest court, or the second busiest court in the Commonwealth. So would you look at the two documents?
And just for the record, the two documents are the handwritten motion to impound and then the criminal docket.
Would you start with the motion to impound, sir? Would you please?
Yes.
Okay. Do you see anything in the four corners of that document that states a date for expiration of the impoundment order?
No.
Would you now look at the next page, the last page of the next exhibit, which is the
Exhibit 5.
docket sheet, okay? And look at the entry for I think it's the 17th. The handwritten entries, I think, are the last page, sir.
Here at the top, the docket entry.
Right, right. Do you see anything in the docket entries made by the clerk that shows an expiration date for the impoundment order?
No.
In either document, do you see anything that looks like separate written findings by the judge?
No.
Now, do you agree with me?
Well, let me qualify that. I don't know whose handwriting this is, but it just says.
I'm talking about the impoundment entry.
Oh, all right. I'm gonna look at it different. I'm sorry, different.
And so you agree with me that a reasonable person looking at the motion and looking at the docket sheet could come to the conclusion that the uniform impoundment procedures were not followed correctly in this case? A reasonable person could conclude that, yes or no?
Well, clearly, there's not a date that he put there, so,
Okay.
but yes.
Do you agree with me that a reasonable and professional assistant district attorney could take steps to resolve that problem if he perceived that to be a problem?
But the DA has broad authority.
And would there be anything, and do you agree with me that the uniform rules of impoundment procedure have a preference for redaction over total impoundment?
I definitely agree with that.
Okay. So if an assistant district attorney saw the situation, and at the end of the day, more information was made public than had been at the morning, when everything was impounded, and the impoundment order had been lifted, would there be anything professionally improper with the actions of that attorney in doing that?
Based on your question, no.
You said that you were acting on what you knew at the time, is that right?
That's correct.
And any reason to believe that my client wasn't acting on what he knew at the time? And you don't know what transpired in any communications between Mr. Early and Mr. Travers, is that correct?
No.
That's all I have, thank you.
Okay, thank you very much.
I have one question on redirect.
Okay, oh, thank you, thank you. Apologize, okay.
Judge, what is the danger of pretrial publicity on an impounded case?
By its definition, it wouldn't be, because you wouldn't have access to the facts contained in the document.
That's all I have, thank you.
This is one of the rare times an attorney says, I have one question, and she had one question. Okay, so,
I have one question.
okay.
And if the impoundment order were lifted, or if the impoundment order were violated, would the answer be the same?
No.
You have anything?
Can I have a second, Judge?
What's that?
Can I have a second?
Oh, sure.
Myself,
Oh, sure, 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 thank you.
I'm all set, thank you, Judge.
Okay, Mr. Wasconi, you have anything?
I have nothing further.
Mr. Bourgeois?
I already got in the last word.
Okay, very good. So, wait, hold on one second. I apologize. I think that's a question. This is a question. Is it common practice for an impounded order to be violated or disregarded?
No.
Okay.
No, it's actually, that would be a serious infraction.
That would be serious infraction. Okay. Okay, great.
I have a follow-up on that.
Okay. Okay. And this is for the record. This is Mr. Burke. Go ahead, Mr. Burke.
Thank you, Judge.
Okay.
Judge Dawley, we don't know who leaked this to the media, do we?
I have no idea.
But you would agree with me, whoever did that, that's a clear violation of the impoundment order.
If the information was leaked after the impoundment order issued, that's a serious violation of a court order.
You know how many people had access to that particular report?
I do not.
Thank you. Mr. I'm just noting, Mr. Wasconi is talking to his client. So, Mr., do you have any questions you want to ask and follow up?
No, I don't.
Okay, Mr. Bourgeois.
My only question is, would you like this copy of, which is unmarked, of the impoundment procedure?
Do you want to offer? If you want to offer it, I'll accept it.
We've already asked, and I think you agreed you would take judicial
Sure.
notice of it, so I haven't.
Yeah, so if you, yeah, that would be wonderful.
Thanks.
Okay. Thank you. Thank you. Ms. Scully stepped out, so standing in his stead, Ms. Fiaro, do you have anything based on that question? Do you have anything based on the last few questions?
No.
Thank you.
No.
Sir, thank you very much. I know
Thank
you're
you.
busy, so thank you very much.
Thank you.
So, no, have a good holiday
Don't
now.
forget your
Oh, thank you.
Record for the transcript, the judge's attorney's name.
Dan.
Oh, yeah. Oh, this is the attorney. Oh,
I just
so
want you-
what?
the transcript, so I can see.
Thank you very much, sir. Thank you. Okay, where do we stand now?
That's all the witnesses we have for today. It has been brought to our attention just now that one of our witnesses may be watching the proceedings.
Okay,
And it's live streamed, so, and I thought, I wasn't sure what the sequestration order
I don't think we
was.
never
We didn't
really
resolve
got to
it.
that point,
Okay,
and I think
all
I think we left the sequestration order to the point where if there was a live witness in court, they would have to leave.
Alright, I just,
However, if you've come to that information, I would ask you to share that information with the other parties so that they
Can
could,
we put it on the record who it is, Judge, that's been watching?
well, I'm not accusing anybody of any
No, I'm just looking.
violation, so,
Obviously, she's just said that it's come to their attention.
sure. Well, what I'm gonna,
I'd like to know who it is.
that's what I've asked her to do.
Oh, I'm sorry.
Yeah, so what I asked her to do was to share that information with the respondents' counsel, and then you do with that as you wish.
thank you.
Okay, so just make sure you do that. So, okay, so, okay, so, where do we stand? So, for Friday, what witnesses are you gonna call tomorrow?
To Presidio.
Okay, and are there any other witnesses?
There are not.
Okay, so, and Ms. Bourgeois, you're not gonna be at the troopers testifying tomorrow, you're not gonna be here tomorrow, correct?
That's correct. I've asked co-counsel to ask him a couple of questions, but I have no objection to it proceeding without me here.
Okay, very good. Now, for Wednesday, now this is now plenty of time to prepare from, I can understand why you had some trouble this week, but for next week, there should be really no excuses. So what witnesses are you gonna call on Wednesday? Okay, this is Ms. Moran. Thank you.
Commissioner, it's after Trooper Sevier testifies on Friday, we anticipate calling only 2 more witnesses on Wednesday. Brendan Keenan and Judge Despotopoulos.
Okay, and
And
Judge.
my understanding is Mr. Travers follows Mr. King.
Yes.
Yeah,
The way I
that-
said
yeah.
them doesn't necessarily mean the way we're putting them in, I just
Yeah,
said that.
that's, that would be
Sorry about
fine. So then, so Clerk Keenan's gonna testify, then we're gonna
Yes.
take a witness out of order, which is going to be Mr. Travers, and then we're gonna return to you with the judge.
Unless we do the judge first and then Brendan Keenan, and then we can do Mr. Travers.
Yeah, I just wanna make sure we can get all that done in one day.
Yeah, I made, I guess I can tell you, I mean, I'll be here back in Tuesday evening and I'm flying out at 4:30 on Thursday.
Okay,
So if we get tight on time, I may ask for you for some help.
yeah, no, that won't be a problem. So I'll just ask the parties to talk amongst themselves. It would seem to me to accommodate Mr. Bourgeois, we should probably call Clerk Keenan first and then Mr. Travers, and then we'll finish up with the judge. Is the judge gonna be coming in or is he gonna be Zooming?
He's coming in person.
Oh, he's coming in. And, as I said, to accommodate him, so he doesn't have to come back, we can stay till 5 on Wednesday. Okay? So, and that'll be it, correct? So then you're resting.
Understood. I don't think we anticipate calling anyone else.
Okay, so that's Wednesday. So you anticipate resting at that point?
Yes.
And, subject to something coming up.
Can I ask you a question?
Yeah, sure.
Is Mr. Keenan live or on video?
He's live.
Okay. So, so this is, it's moving along pretty expeditiously here. So that Wednesday, so it seems to me that on Thursday, the respondents can start putting on their case, okay? And you'll contact the petitioner and let her know the order of the witnesses, so, she can prepare, or they can prepare, okay? So, okay, that won't be a problem. So, okay, so I'll
Can we
see.
get that information by Friday?
No,
I have total faith in the ability of the parties to work together. So if there's a problem, you'll bring it to my attention and then I'll try to resolve it. So, okay, so we have one witness tomorrow, so Have a great evening tonight, and we'll see everybody tomorrow, and good luck with your medical appointment, and we'll see you next week. Thank you.